and those frankly continue. One of the things that we discussed at the time of the plea was giving Mr. Eldon Brady an opportunity to get the evaluations, which we now have, in an effort to hopefully demonstrate in some regard why Paul did these things. Was it a psychological condition? Was there some manipulation taking place? And quite frankly, I think, just as my feeling is there's good and bad with Paul, I think both of these assessments reflect the same thing. What is absolutely clear from both of these assessments is that whatever upbringing Paul had from his mother and frankly from his father as well, led to him being how he is today. And that was a childhood that I think both reports indicate was marked with abuse and neglect, a very traumatic upbringing, moved around a lot, and what also rings through in these assessments is that nobody did anything to get Paul any help when it could have made a difference. So that is in some respects that's the good part of this, because it does seek to at least explain in some regard why Paul behaved the way that he did. But there's bad in here as well. I'm sure the court will note this, but the one sentence that struck me in Dr. Shazer's report is that it says, in my opinion, Paul Ferguson was predisposed to abuse his brother independent of his mother's presence and active influence in his life. That's frankly scary. And there's other scary parts of this as well that indicate that Paul was, at least in some respect, predisposed to being essentially a bully. And that's how you could view his behavior, is that he was a bully. Now, nobody, I think, would expect any bully to take it to the extreme of actually killing a person, although certainly it does happen, but nobody would expect that was an intentional outcome that Paul sought here. And we can't lose sight of the fact that Paul didn't become this way in a vacuum, that his upbringing in some respects led to him being predisposed, as this report indicates, and I think the other report references it as well, that he was predisposed to already doing some of these things. Frankly, I think that Ms. Vander Ark took advantage of that and used Paul because she saw an opportunity to have Paul do the horrible things that she couldn't do herself or wouldn't do herself, but be done at her direction. And Paul was unfortunately willing to go along with those things because of everything that had happened to him, because of his traumatic upbringing, and because of the conditions that he did have that led to that. So it's hard to balance these things out. Certainly we did not have this report at the time that Paul pled, and I don't know that in looking at this report the decision that was made in this case would be any different. But certainly there are things here that would have been nice to have been able to consider, but we didn't have the benefit of that. And as I told the court, I think I've told the court on several occasions in speaking to the jury, they were, in Ms. Vander Ark's case, very much impressed by, might not be the right word, but certainly factored in Paul's testimony a great deal. Believed that he was telling the truth, believed that he was honest about what his role in this and Ms. Vander Ark's role in this. So I think his testimony was instrumental in achieving the conviction that was achieved here against Ms. Vander Ark. So I certainly owe Paul that consideration, but beyond that, I certainly don't envy the position the court is in today. In balancing everything that has taken place here, the good and the bad, even in this report, and the good and the bad with Paul, I will stick to the agreement that we have made here. I will ask the court to sentence within the sentencing guidelines in this case. Certainly the court is obviously free to exceed the guidelines if it feels there's a basis to do so, and quite frankly, there are reasons to exceed the guidelines. In some respects, there's reasons to go below the guidelines as well. So literally, I think any number that the court chooses to pick here, I think would be the appropriate sentence, because I think it's a difficult balancing act that the court has to do here. But my commitment was and continues to be that we would ask the court to sentence within the sentencing guidelines. I would ask the court, however, to impose a maximum number here that is essentially equivalent to what Paul's life expectancy would be. And the reason for that is that if some of the bad that's indicated in these reports is actually present and Paul does not receive treatment for that, and those conditions that are noted here, most notably the potential antisocial disorder, essentially a sociopath, if those things are borne out in the prison system, that the prison system then has the opportunity to keep Paul locked up as long as possible. I hope that he can get some treatment inside there, but the bad in here has got to be addressed, and if it's not, then certainly Paul does represent a threat to the public moving forward because of his disassociation, essentially, from feeling empathy or feeling bad about the things that he had done. In the moment, it did not appear that Paul felt bad about those things. There certainly was a moment where he thought he needed to let his mother know that Timothy was very thin and that they should start feeding him. But overall, what comes through in these reports is that for the most part, those were absent. And the text messages, I think, even bear that out as well. That even after that noting of the fact that Timothy was very thin and that they needed to start feeding him, Paul was still a willing participant in the truly tragic and horrible things that happened in the last days of Timothy's life, including the prolonged ice bath that Paul watched over. So certainly that bad needs to be addressed as well. So again, I don't envy the position the court is in today. I will stick with my commitment here and ask the court to sentence within the sentencing guidelines. But quite frankly, any number that the court picks here, I think would be an appropriate sentence for Mr. Ferguson. I'm pleased that we've been able to achieve whatever justice we could for Timothy here in both of these convictions, and certainly the two people most directly responsible for what happened to Timothy are going to, in all likelihood, be incarcerated for an extended period of time, certainly in Ms. Vander Ark's case for the rest of her life, which is completely justified under these circumstances. So I would ask the court to, as it will have to do, to weigh the good and the bad here in these reports, and I trust the court's I trust whatever decision the court makes here.
All right, thank you, Mr. Roberts. Mr. Eldon Brady, the elocution.
Your Honor, I'd like to start by responding to a point that Mr. Robert made before I go into the multiple points I plan to address. I understand the prosecutor's characterization of Paul as being the enforcer, as being the primary one. But I believe part of that is based simply on the evidence that we have. This court's heard the text messages, extensive text messages, of Ms. Vander Ark instructing Paul on what he was to do to Timothy. You've heard Paul's testimony about what he was instructed to do and what he did. The rest of the time, when she was there doing whatever she did, Paul was at work. She didn't have to send text messages to herself. Timothy's not here to talk about what happened when it was just him and his mother. So I disagree with that characterization. I believe, based on what we do know of Ms. Vander Ark, that there was far, far more that went on. There was far, far more that she did that there simply is no evidence of, no one to speak of, because the only person alive who knows what she did is her. Beyond that, reading the pre-sentence report in this case, I can't argue with the reasonableness of the recommendations in the pre-sentence report. I also really can't add anything about the offense, about the details of what happened to Timothy. You presided over the same trial that I watched. I know in motions, other paperwork submitted to the court, you're aware of far, far more than what came out publicly, what was submitted to the jury. But I'd ask the court to consider, I think there's 5 fronts on which Paul should be evaluated very differently than where his mother is. And the first is just capacity to understand. We heard Ms. Vander Ark's attorney argue they didn't know what they were doing. They didn't realize that it could kill him or cause that level of injury. And I don't have to come to a conclusion. I don't have to say I think that's right or that's wrong to understand that a 41-year-old law school graduate who was, by her own boasting, at the top of her class, who passed the bar with flying colors, who would have been an attorney, well, academically was qualified to be an attorney. We never got an answer of why she wasn't. And who worked for the court, both from a legal front, from a moral front, from an intellectual front, had far, far more capacity to understand what she was doing and the potential consequences of what she was doing than her son, who was a 20-year-old high school graduate who worked as a dishwasher. There's simply no comparison in capacity, in life experience, in an ability to understand and recognize what was happening. Second, well, we recognize, for purposes of the child abuse statute, for purposes of Paul's plea, the law may not distinguish between a parent and another person over the age of 18 who's placed in charge of a child. We all know a mother has a very different role than a sibling. We all know that there's a certain level of rivalry, a certain level of competition that we expect between siblings, which is very different than the care that we expect from parents. Third, I'll come back to the text messages. It was very clear Paul was the follower and his mother was the leader in this case. Listening to over an hour of text messages read during her trial, there's pieces missing. We don't get the whole story because she talked to him over the camera, or she talked to him on the phone, or she talked to him in person. But what is very clear from those text messages is there is not a single time that Paul gives an instruction. Every single time an instruction is given, you need to do this, it is given by her. Fourth, and Mr. Roberts has addressed this regarding Paul's cooperation. Once the gravity of what happened sank in, I believe from the reports that was a day or so after, Paul has shown remorse. He's shown confusion over how he could have done this and recognition that it was wrong. He's testified honestly. He's fully cooperated in many areas in ways that were not of clear benefit to him. His mother did none of these things. She took the stand and lied, redirected. It's not my fault. I didn't do anything wrong. And fifth, and I think very important in looking at the evaluation of Mr. Ferguson, it's very clear that he and his other siblings were also victims of their mother. CPS involvement going back to when they were in elementary school, back when Timothy was 18 months old. A third grade teacher who said Paul and Nolan are secretive about what happens at home. They're not supposed to talk about it. So when Mr. Johnson argued in cross-examination to Paul, why didn't you report it to somebody? A lifetime of being told you're not supposed to talk about what goes on at home. A lifetime of being isolated, separated from peers, having no meaningful social contacts outside his household. That all started with her. A record that when Timothy was 18 months old, when Paul was 7, that Timothy was underfed, failure to thrive. Paul didn't have anything to do with that. He was 7. But that was the pattern. That was his entire life. That was his entire framework. That was what she taught him from the beginning, or at times failed to teach him through neglect. Mr. Roberts referenced, and I don't remember if it was in sentencing or in his closing argument, that the difference between Timothy and Paul was that Paul was useful. Timothy wasn't. At least not to their mother. And I wouldn't disagree with that characterization. But I think that's important for the court to consider. Timothy was treated the way he was because he wasn't useful. That's how children in their mother's household were treated if they weren't useful. And I believe at some level, some part of Paul understood that. He understood that we do these things to Timothy because he misbehaves, because he doesn't follow instruction, and because he's not useful. And part of understanding that is also understanding that if he didn't follow instructions, if he misbehaved, if he got on her bad side, that he could once again be subject to some of the same mistreatment. On the neglect front, I don't think any of them ever ceased to be subject to that mistreatment. And I'll end with his mother's own words from the text messages read in court. To Paul, quote, "If he falls asleep from you, not watching, that is not going to end well for either of you." Thank you.
Your Honor, if I could just make one more brief point, and it's not in response to anything Mr. Eldon Brady has said, but the court referenced that it's had a lot of outside people contacting the court. I certainly have had that as well. And one of the consistent themes there is people believing that Paul suffers, or not suffers, it's not a suffering, that Paul is on the autism spectrum. I think it's important to note that in both of these evaluations, that's not borne out. Certainly people may have that belief and think that that should be a factor here, but there's nothing in either one of these reports that supports that conclusion. So I just want to note that. That is certainly something that I think the court could have considered, but there's nothing in the report that would support that, and I don't think Mr. Eldon Brady would disagree with that point.
Yeah. I was going to reference that in my comments as well, so.
Your Honor, I think the reports do bear out that some of the characteristics that those individuals are observing and coming to that conclusion are connected to that neglect and abuse, and I believe it was Dr. Farrat characterized as normalization of abnormal behavior. So while I agree that both analysis seem to have come to the conclusion that that diagnosis is inappropriate, I don't believe that those observations by the individuals mentioning that are ungrounded. It's simply that those behavioral characteristics come from a different source and therefore do not lead to the ability to officially diagnose with that condition. That does not change the fact that those characteristics are there, that those characteristics are relevant to Paul's interactions with his mother, or that those characteristics are relevant to ongoing treatment services that Paul will need moving forward.
Okay. Mr. Ferguson, anything you wish to say prior to sentencing?
Yes, Your Honor. What reasons could justify my actions? I could make up 1,000 and never believe one. What words could voice my regrets? I can think of millions, yet never feel it's enough. If I could do it all again and do it right, I would. I feel I will pay for my choices and yet never feel better, because he's still gone. I have had time to think during my time in Muskegon County Jail, and I've realized many things about myself that I might never have considered otherwise. My problems and flaws, to put it simply, are the place to begin correction of self. I ask the judge for nothing more than mercy and fairness, to offer me compassion so I might learn from him. I only hope to better myself in the coming days and serve my time with what little honor I have left, and to make right my faults in search of a better tomorrow.
First and foremost, as Mr. Roberts referenced, the court was in a difficult position This particular case, I think a lot of individuals saw Mr. Ferguson testify, and I think there was concerns about intellectual potential disabilities, and the court was concerned with that as well. There was also a concern whether Mr. Ferguson was the target of manipulation on behalf of his mother, and the reports that were submitted to the court really did help me a lot in trying to parse those issues out. The report specifically by Dr. Shazer is very in-depth and very well done, and I thank him for doing such a detailed analysis. So the first concern of the court was whether or not Mr. Ferguson was suffering from some sort of intellectual disability, whether it be autism or something else. And there's a couple references to that throughout his Dr. Shazer's report. And specifically, the first reference that the court had highlighted was on page 2 of the report, first full paragraph, and it says, in my opinion, he, referring to Mr. Ferguson, was clearly either psychotic or suffering from symptoms of a mood disorder at the time of the court interview. And he was apparently functioning within at least the normal range of intellectual ability at this time. Thus, in my opinion, he does not suffer from a chronic psychotic disorder, a chronic mood disorder, or an intellectual disability. There's another reference more to the end of the report where he indicates, thus, his referring to Mr. Ferguson, his educational history is inconsistent with him suffering from intellectual deficits, and as noted above, he was apparently functioning within at least the normal range of intellectual ability at the time of the court interview. In my opinion, the defendant clearly does not suffer from an intellectual disability. So the court, that was helpful in the court because and some of the letters that I received as well, Mr. Roberts indicated that there was concern that Mr. Ferguson was autistic. And I think probably more toward that was easier to maybe manipulate him and that kind of thing. And certainly the court does take someone's intellectual capacity into consideration. I think it's important to understand the full situation. So the court, and although those are two small portions of the opinion that the court referenced, they're borne out by much more in detail history in Dr. Shazer's report. Specifically, Dr. Shazer analyzed every statement that the defendant gave the police. He also watched the testimony of Mr. Ferguson, interviewed him himself. He also looked through his history from the Oklahoma Department of Health and Human Services. He looked through his history from school records, from various psychological assessments that were conducted throughout his life based on the report. So I think that opinion is well grounded in not only his interview, his review of educational records, his review of mental health records, and everything else, Health West records currently from when he was assessed when he became in Muskegon County Jail. So the court finds that to be quite persuasive in terms of whether or not Mr. Ferguson is suffering from any intellectual disability. And the court concludes based on this report, well-written report, well-grounded in fact and history of the defendant, that he was not suffering from an intellectual disability currently or at the time of this offense. The second thing is whether or not Mr. Ferguson was somehow manipulated or coerced by his mother. I think all of us would like to believe that this is a product of manipulation, that this is simply somebody doing something that they were told to do, that they were afraid. Mr. Alvin Brady mentioned it in his allocution regarding the specific text messages. Well, those specific text messages I heard as well at the trial. Shortly after the trial concluded, I asked the prosecutor's office for a complete copy of every single text messages that would occur between Ms. Vander Ark and Mr. Ferguson, because I didn't want just the snippets, the kind of highlights or the real, juicy stuff, for lack of a better term. I wanted to understand completely what the conversation was between these individuals. I read every single text message, every one of them. I think there's thousands in there, and I read it 3 times now. 3 times in total. I read it 2 months ago, I read it a month ago, and I read it last week Friday. The entire afternoon was spent reading through these things. And I think it's clear to me that Mr. Ferguson, although he says that he was scared of his mother, or there's an allegation of that standpoint, I find that just the opposite to be true based on those text messages. There is some mention about punishment, but I think Mr. Ferguson, in my opinion, being submissive, for lack of a better term, to his mother was a result that he really had nowhere else to go. He had been kicked out from his father's house for failing to obey his father's rules and for other things. And he went to his mother's house, and I don't think Mr. Ferguson really had anywhere else to go. I think he was sort of beholden to his mother in terms of, well, there's going to be consequences. Although there are some text messages, 1 or 2 of those, that bear that out, this strikes me in the text messages as more of a collaborative effort. In fact, there's some text messages where Ms. Vander Ark actually tells Mr. Ferguson that if Ms. Timothy does not behave, essentially, I'm going to leave him to you, as in that he's going to let the dog out and just log off the chain. And Mr. Ferguson also several times essentially tells his mother things that are going on that are bad. And I think it's because he wants his mother to give him the permission to go ahead and engage in punishment. So in terms of whether or not his mother, he was somehow afraid of his mother, I don't think that to be the case. Now, that was my initial feeling about it, and what I took it as, and that's why I wanted the assessment regarding whether or not he was being manipulated. And luckily, we did get one from the second one I referenced was from Dr. Farhat, which is specifically, I think he was asked to assess this particular question. And in the beginning of his assessment, he says that specifically, I was asked to assess whether Mr. Ferguson possessed a psychological disorder of traits that would render him significantly susceptible to manipulation, coercion, or suggestibility. After conducting the evaluation, I could not substantiate these traits as they pertain to the commission of the offense. As such, this report will instead explain the nature of the evaluation and my overall opinions regarding Mr. Ferguson's psychological functioning. He also opined regarding his intellectual abilities. He says, from a diagnostic standpoint, I did not find sufficient evidence to support Mr. Ferguson meeting criteria for any specific mental disorder. While one may consider whether his presentation suggested a neurodevelopmental condition, for example, e.g. autism spectrum disorder, I did not find this to be an appropriate label. Instead, I attributed his overall demeanor and presentation to factors such as a lack of socialization, normalization of abnormal dynamics and experiences, poor interpersonal skills, and emotional dysregulation. He also indicated later on that page that I was initially asked to evaluate whether Mr. Ferguson had a mental condition or traits that would have rendered him susceptible to coercion, manipulation, or suggestibility at the time of the offense. Ultimately, I could not arrive at this conclusion based on the totality of available information. Available evidence noted that he was capable of appreciating the abuse towards his brother, that he was capable of recognizing the detrimental impact it had, and that he at times disobeyed Ms. Vander Ark and tried to provide his brother with aid and support. Furthermore, despite reporting that he was under Ms. Vander Ark's, quote, psychological hold, he adamantly denied that he was coerced or manipulated into enforcing the abuse. Additionally, he recognized to some degree pleasure in having power and control over his younger brother. In this sense, while I acknowledge that he reported experiencing fear and concerns of disobeying Ms. Vander Ark, I could not reliably substantiate his involvement as being a byproduct of suggestibility suggestibility, or coercion. So what this court is left to conclude is that Mr. Ferguson, the way I look at this is that Mr. Ferguson in these reports, and a lot of these, throughout the report, there's talk about how Mr. Ferguson bullied his brother when he was younger. There's a mention, his stepsister, who I think was allocated on behalf of his mother, or on behalf of Paul, Timothy, at Miss Vander Ark's sentencing. He says the stepsister, and this is before the police even really told her about exactly what had happened in here. It says the stepsister reportedly told the police that, quote, she doesn't know how involved Paul was in this situation, but he is the biggest bully she has ever met in her life, and he found genuine joy in tormenting Timothy whenever possible.
Judge, for clarification, I don't think that was Millie, that the
Okay,
stepsister
so maybe
was not
I'm wrong.
Millie.
Okay, so perhaps I'm wrong about that. But this was someone who, without even knowing the full details, reported that. In one of the interviews, Mr. Ferguson indicated that he liked getting praised by Shonda and admitted he liked having control over Timothy. He reportedly admitted having power over somebody feels good. Later in the interview, I asked him whether he had felt ashamed at the time when he was abusing his brother, and he said, quote, no, he had not. I asked whether he had recognized his action as morally wrong at the time, and he again said, quote, no, he had not. He then volunteered that on one occasion, quote, I sent her a photo of how thin he was, and when I asked why he did this, he explained that I was worried. When asked when he was worried about Mr. Ferguson, Ferguson replied that he had been concerned for his house, observing that he was nothing but bones. I asked him whether he had, at the moment, thought that this abusive behavior was wrong, and he replied that, quote, that thought never even crossed my mind. A treatment plan back from July 22nd of 2012 indicates that, quote, client, meaning Mr. Ferguson, sometimes bullies his younger brother, the decedent, Timothy. The report also mentions cruelty to animals, stealing, abuse. His mother at the time, back in 2018, told staff at the clinic he's become bossy, telling his siblings what to do. For Mr. Ferguson's part, reportedly, when commenting about his being irritable, he admits that this is due to his younger siblings not listening. He gets physically aggressive towards his younger siblings. He also tried to lock his younger brother, i.e. apparently a reference to the decedent, in the closet because his brother wouldn't listen to him. So the court read this and certainly looks at this as someone who is predisposed, I think was the ultimate conclusion, predisposed to abuse his brother. Specifically, the victim in this case, in a history of doing that. Now, I have no doubt in my mind that Mr. Ferguson is a result of years and years and years of physical neglect and abuse on behalf of his mother. No doubt in my mind that's borne out of this report. But the court is asked to essentially ignore the decisions or his behavior because of that, and to somehow say that we're going to minimize the damage and what he did in this case because of that. If the court started imposing that standard, I think we would be in real trouble, because every defendant that comes before this court has a horrible history, I would say. That's the reason they're here. People that have supportive parents and things go good for them typically don't come here. Now, that's not always the case. Believe me, there's a lot of interventions. But everybody has a history. What I was looking at is whether or not this is a product of his mother or his situation. And what I can conclude is that this is not. Mr. Ferguson is trying to shift blame from his mother, from him to his mother, to say that somehow, well, if it wasn't for her, I wouldn't have done this. Or she's the one that did this. At the trial, well, at her order, at her order, at her order. He kept saying it over and over and over again, and just keep underscoring the point. And if that had been an isolated incident, if that had been one or two of these things, if that had been a punishment that he administered, maybe the court could accept that. But we have an individual who was in a household for 6 months, intentionally himself engaging in torture of another person. And he doesn't, well, I'm worried about my mom's going to say, clearly it's not borne out in these reports. He had the ability to disobey his mom. In fact, he was on the stand and almost boasted that, well, I gave him extra food. Weren't you worried about how your mom was going to be upset? I still gave him extra food. So what that tells me is that this has been a careful, manipulated story by Mr. Ferguson from the very beginning of this thing, that he's going to put the blame on his mom. I'm going to be manipulated. I have Asperger's syndrome. I have autism. I have Stockholm syndrome. There's mention of him saying, well, maybe I have Stockholm syndrome in here. No, this is an individual. What the truth of this is that we have two individuals that lack empathy, who lack emotion, and both of them, the triggering factor in this report, the triggering factor that caused this abuse was the removal of the husband, of stepdad. Once he was gone, these two individuals were free to torture somebody, and they did it. That's what they did. And I think Ms. Vander Ark did use Mr. Ferguson. I think that she knew from his history that he was predisposed to torment Timothy. I think that she knew that he would have no problem doing that. And Mr. Ferguson walked through that door and was happy to be the enforcer, was happy to do it, and continued to torture his brother over and over and over and over until he was a shell of a person, until he was dead, died from starvation, died from hypothermia. He had no fat on him, barely any muscle on him. And the whole time, just letting it happen. The report says, it appears that the stepfather's presence in the home had prevented Paul and his mother from abusing the victim. Again, it wasn't anything to do, they were just holding him back, essentially. The overall opinion, which I think is important, says, in my opinion, although the defendant's participation in the abuse was in a part a function of his social milieu and living situation, these contextual factors were not a necessary condition for his participation. As previously noted, mental health records contain information to the effect that while they were still living with their father and stepmother, and reportedly had no contact with their mother, Mr. Ferguson's stepmother told the psychiatrist that he had become bossy, telling his sibling what to do, and the defendant himself that he would become irritable due to his younger siblings not listening. He gets physically aggressive, told his younger sibling. He also reports that he's gotten irritated with his siblings and has pushed them in retaliation. He's also tried to lock his younger brother, the decedent, in the closet because his brothers wouldn't listen to him. Consistent with this, Norton Shores Police Department documents indicate that Mr. Ferguson's stepsister told police, quote, he is the biggest bully she's ever in her life, and he found genuine joy in tormenting Timothy whenever possible when they were living in the biological father's home. Notably, the defendant allegedly engaged in this abusive behavior despite there being any safety rules in place, and despite his father and stepmother disapproving of this behavior to such an extent that they removed him from their home once he turned 18 because of it. In my opinion, Paul Ferguson was predisposed to abuse his brother independent of his mother's present an active influence in his life. Nonetheless, in my opinion, Mr. Ferguson's involvement in repeated acts of abuse that amounted to physical and psychological torture over a period of months reflects a general lack of empathy for his brother and a lack of remorse for his actions. Concludes that, in my opinion, there is no reason to believe that Mr. Ferguson's conduct disorder has remitted or that his participation in the abuse of his brother was not an expression of a persistent pattern of antisocial conduct. The court is concerned that Mr. Ferguson will not get the help he needs in prison. I think he's one step away from becoming a psychopath like his mother, and the court is concerned that he represents a danger to the public. That if released, he would represent a significant danger to the public. The charge here is child abuse, and I don't think this charge or the sentencing guidelines take into adequate consideration of the long sustained torture in this case. As I indicated in Ms. Vander Ark's testimony, there was a long period of months of various punishments, including bread with hot sauce. There's hot sauce that apparently contains 2 of the hottest peppers that we have in the world. Wall sits for an individual who practically had no muscle left. Running up and down stairs, cleaning out a garage with no pants on, sleep deprivation in itself. Putting alarms on him so he couldn't move or sleep. Making him puke up food. There's bathroom timers. Sleeping in the closet with a tarp down, which quite frankly might be considered animal abuse. But we have a human being here. Making his hands over his head. And then at the end of his life, an 8-hour practically ice bath that killed him. So no, I don't think any of those things are adequately taken into consideration by the guidelines. And I don't think the guidelines, quite frankly, can even, these guidelines don't justify Mr. Ferguson's actions. Mr. Ferguson, I think you are a product of your environment, but I don't believe you that you're sorry. I don't think you have empathy. I don't think you have any emotion whatsoever. And that's what scares the court. It really scares me. I think you're sorry that you're here. I think you're sorry you got caught. I don't think you wanted Tim to die either, like your mother, because you would get caught and you wouldn't torture him anymore. And believe me, I've tried to sit here and try to think, well, maybe Mr. Ferguson's not as bad as Mom. I think you're just as bad, if not worse. If not worse. Because you had a job. You could have, Mr. Johnson actually asked you, couldn't you have brought home a thing of food for him? You could have gone to a neighbor and said, hey, my mom's abusing him. You could have grabbed him and got him out of there. You could have done any number of things to stop this. And you chose not to. Your own brother. And this is where we're at. So, based on all that, it's a sentence of the court. You serve 30 years to 100 years, Michigan Department of Corrections. Credit for 592 days you've already served. Court's going to assess a $68 state cost, $130 crime-based assessment, no additional fines or costs. Mr. Ferguson, you have a right to file an appeal in this case. If you're finding anything, if it's retained an attorney, who will be appointed to a public expense. Request for the assistance of a lawyer must be made in 42 days from today's date. Clerk is handing you a form that you must complete. Return to the court in that 42 days if you wish to request the appointment of an attorney. Appeal or adjourned.
What do you want to do next in jail, Mr. Goins?
Most of them are jail, Judge.
What's that? Cleansing?
I heard a loud bang. I knew.
Or at least I was.
A famous actor in a movie set accident that ended in tragedy.
I turn the gun goes off.
Now, Alec Baldwin and the film's armorer have both been charged with involuntary manslaughter.
Just because it's an accident doesn't mean that it's not criminal.
Court TV takes you inside the courtroom as Hannah Gutierrez faces a jury.
The Baldwin movie shooting trial. Live coverage today, only on Court TV.
Dr. Shazer's report. Specifically, Dr. Shazer analyzed every statement that the defendant gave to the police. He also watched the testimony of Mr. Ferguson, interviewed him himself. He also looked through his history from the Oklahoma Department of Health and Human Services. He looked through his history from school records, from various psychological assessments that were conducted throughout his life based on the reports. So I think that opinion is well grounded in not only his interview, his review of educational records, his review of mental health records, and everything else, Health West records currently from when he was assessed when he became in the Muskegon County Jail. So the court finds that to be quite persuasive in terms of whether or not Mr. Ferguson is suffering from any intellectual disability, and the court concludes based on this report, well-written report, well-grounded in fact and history of the defendant, that he was not suffering from an intellectual disability currently or at the time of this offense. The second thing is whether or not Mr. Ferguson was somehow manipulated or coerced by his mother. I think all of us would like to believe that this is a product of manipulation, that this is simply somebody doing something that they were told to do, that they were afraid. Mr. Eldon Brady mentioned it in his allocution regarding the specific text messages. Well, those specific text messages I heard as well at the trial. Shortly after the trial concluded, I had asked the prosecutor's office for a complete copy of every single text messages that would occur between Ms. Vander Ark and Mr. Ferguson, because I didn't want just the snippets, the kind of highlights, or the real juicy stuff, for lack of a better term. I wanted to understand completely what the conversation was between these individuals. I read every single text message, every one of them. I think there's thousands in there, and I've read it 3 times now. 3 times in total. I read it 2 months ago, I read it a month ago, and I read it last week Friday. The entire afternoon was spent reading through these things, and I think it's clear to me that Mr. Ferguson, although he says that he was scared of his mother, or there's an allegation of that standpoint, I find that just the opposite to be true based on those text messages. There is some mention about punishment, but I think Mr. Ferguson, in my opinion, being submissive, for lack of a better term, to his mother was a result that he really had nowhere else to go. He had been kicked out from his father's house for failing to obey his father's rules and for other things. And he went to his mother's house, and I don't think Mr. Ferguson really had anywhere else to go. I think he was sort of beholden to his mother in terms of, well, there's going to be consequences. Although there are some text messages, 1 or 2 of those, that bear that out, this strikes me in the text messages as more of a collaborative effort. In fact, there's some text messages where Ms. Vander Ark actually tells Mr. Ferguson that if Ms. Timothy does not behave, essentially, I'm going to leave him to you, as in that he's going to let the dog out and just log off the chain. And Mr. Ferguson also several times essentially tells his mother things that are going on that are bad. And I think it's because he wants his mother to give him the permission to go ahead and engage in punishment. So in terms of whether or not his mother, he was somehow afraid of his mother, I don't think that to be the case. Now, that was my initial feeling about it, and what I took it as, and that's why I wanted the assessment regarding whether or not he was being manipulated. And luckily, we did get one from the second one I referenced was from Dr. Farhat, which is specifically, I think he was asked to assess this particular question, and in the beginning of his assessment, he says that specifically, I was asked to assess whether Mr. Ferguson possessed a psychological disorder of traits that would render him significantly susceptible to manipulation, coercion, or suggestibility. After conducting the evaluation, I could not substantiate these traits as they pertain to the commission of the offense. As such, this report will instead explain the nature of the evaluation and my overall opinions regarding Mr. Ferguson's psychological functioning. He also opined regarding his intellectual abilities. He says, from a diagnostic standpoint, I did not find sufficient evidence to support Mr. Ferguson meeting criteria for any specific mental disorder. While one may consider whether his presentation suggested a neurodevelopmental condition, e.g. autism spectrum disorder, I did not find this to be an appropriate label. Instead, I attributed his overall demeanor and presentation to factors such as a lack of socialization, normalization of abnormal dynamics and experiences, poor interpersonal skills, and emotional dysregulation. He also indicated later on that page that I was initially asked to evaluate whether Mr. Ferguson had a mental condition or traits that would have rendered him susceptible to coercion, manipulation, or suggestibility at the time of the offense. Ultimately, I could not arrive at this conclusion based on the totality of the available information. Available evidence noted that he was capable of appreciating the abuse towards his brother, that he was capable of recognizing the detrimental impact it had, and that he at times disobeyed Miss Vander Ark and tried to provide his brother with aid and support. Furthermore, despite reporting that he was under Miss Vander Ark's, quote, psychological hold, he adamantly denied that he was coerced or manipulated into enforcing the abuse. Additionally, he recognized to some degree pleasure in having power and control over his younger brother. In this sense, while I acknowledge that he reported experiencing fear and concerns of disobeying Miss Vander Ark, I could not reliably substantiate his involvement as being a byproduct of suggestibility or coercion. So what this court is left to conclude is that Mr. Ferguson, the way I look at this is that Mr. Ferguson in these reports, and a lot of these, throughout the report, there's talk about how Mr. Ferguson bullied his brother when he was younger. There's a mention, his stepsister, who I think was allocated on behalf of his mother, or on behalf of Timothy at Miss Vander Ark's sentencing. He says the stepsister, and this is before the police even really told her about exactly what had happened in here. It says the stepsister reportedly told the police that, quote, she doesn't know how involved Paul was in this situation, but he is the biggest bully she has ever met in her life, and he found genuine joy in tormenting Timothy whenever possible.
Judge, for clarification, I don't think that was Millie, that the stepsister.
So maybe I'm wrong.
Yes.
Okay, so perhaps I'm wrong about that. But this was someone who, without even knowing the full details, reported that. In one of the interviews, Mr. Ferguson indicated that he liked getting praised by Shonda and admitted he liked having control over Timothy. He reportedly admitted having power over somebody feels good. Later in the interview, I asked him whether he had felt ashamed at the time when he was abusing his brother, and he said, quote, no, he had not. I asked whether he had recognized his action as morally wrong at the time, and he again said, quote, no, he had not. He then volunteered that on one occasion, quote, I sent her a photo of how thin he was, and when I asked why he did this, he explained that I was worried. When asked when he was worried about Mr. Ferguson, Ferguson replied that he had been concerned for his health, observing that he was nothing but bones. I asked him whether he had, at the moment, thought that this abusive behavior was wrong, and he replied that, quote, that thought never even crossed my mind. A treatment plan back from July 22nd of 2012 indicates that, quote, client, meaning Mr. Ferguson, sometimes bullies his younger brother, the decedent, Timothy. The report also mentions cruelty to animals, stealing, abuse. His mother at the time, back in 2018, told staff.
All right, we're going to hear the sentence from the judge in just a moment. He's delivering the grounds for his opinion there. We're going to hit the pause button. Don't go anywhere. Court TV Live rolls on right after this.
I'm the armor, or at least I was.
A famous actor in a movie set accident that ended in tragedy.
I turn and cock the gun goes off.
Now, Alec Baldwin and the film's armorer have both been charged with involuntary manslaughter.
Just because it's an accident doesn't mean that it's not criminal.
Court TV takes you inside the courtroom as Hannah Gutierrez faces a jury.
The Baldwin movie shooting trial. Live coverage today, only on Court TV.
Weeknights.
Daddy and I have some exciting news.
Laughmore has a new man of the house.
Sounds like a plan that makes everybody happy.
And he runs a pretty tight ship.
You got blackjack. That pays 3 cookies to 2. I have responsibilities.
My game starts in 20 minutes.
You said having kids would be fun.
said making kids would be fun.
Man with a Plan. Weeknights starting at 11:10 Central on Laugh More.
Are you laughing at me?
So hard.
You got us banned from being room parents? I have never been more in love with you.
That's incredible.
No, it's genius. I know. Oh, get it. You'll never understand.
That's gotta hurt, huh?
Alf, what are you doing here?
I used to be a phenomenon. Now I'm reduced to a what are you doing here? You keep me coming back for more.
At Scripps News, reporting your world from the middle matters. Since 1878, Scripps has been a shining light in the middle of the storm.
Stories of survival and hope.
In the middle of the action.
You can see how treacherous the terrain is here.
The middle of it all.
This is a story that began long before.
So when events unfold on every side, see it clearly from the middle. Scripps News. Find with an antenna or on your favorite streaming app.
It was the case that started America's true crime obsession.
My office filed murder charges against O.J. Simpson.
A fallen star, a dream team of lawyers, and all the dramatic courtroom moments that have become legendary.
If it doesn't fit, you must acquit.
Relive the trial that had the world watching.
And made court TV a legend.
The trial of O.J. Simpson. Weekdays noon to 4 on Court TV Legendary Trials.
Jesse Palmer?
So you do remember, and I know you haven't been watching.
I know, but TV's expensive.
Well, now you can watch me live sports and news free. No contracts or fees.
But Jesse, how?
Tableau. Pay once and watch happily ever after. And you can record too.
This sounds like a dream.
Tableau. Learn more at tableautv.com. It's not fantasy, it's reality.
Let's go. Really? That is incredible.
It's the best job in the world.
And that's saying a whole lot. We have evidence of that.
Absolutely.
That's good news.
My curiosity is piqued. Pretty much sums it up.
100%.
A masked hero, a faithful sidekick, a trusty steed, and a boundless trail of blazing adventure.
So you're the masked man? I'm afraid so. Coming after you.
Thundering its way into our weekday lineup.
This mask stands for justice. Come on.
The Lone Ranger. Wednesdays on Grit Extra.
We'll be waiting for them.
Television with backbone.
I'm Kelly Craft in Santa Fe, New Mexico, covering the Baldwin movie shooting trial. You're watching Court TV. You're to justice.
Welcome back to Court TV Live. I'm Julie Grant. Let's take you back to Michigan now. We're about to hear the judge deliver the sentence for Paul Ferguson.
Staff at the clinic, he's become bossy, telling his siblings what to do. For Mr. Ferguson's part, reportedly, when commenting about his being irritable, he admits that this is due to his younger siblings not listening. He gets physically aggressive towards his younger siblings. He also tried to lock his younger brother, i.e. apparently a reference to the decedent, in the closet because his brother wouldn't listen to him. So the court read this and certainly looks at this as someone who is predisposed, I think was the ultimate conclusion, predisposed to abuse his brother. Specifically, the victim in this case. He had a history of doing that. Now, I have no doubt in my mind that Mr. Ferguson is a result of years and years and years of physical neglect and abuse on behalf of his mother. No doubt in my mind that's borne out in this report. but the court is asked to essentially ignore the decisions or his behavior because of that, and to somehow say that we're going to minimize the damage and what he did in this case because of that. If the court started imposing that standard, I think it would be in a real trouble, because every defendant that comes before this court has a horrible history, I would say. That's the reason they're here. People that have supportive parents and things go good for them typically don't come here. Now, that's not always the case. Believe me, there's a lot of interventions, but everybody has a history. And what I was looking at is whether or not this is a product of his mother or his situation. And what I can conclude is that this is not. Mr. Ferguson is trying to shift blame from his mother, from him to his mother, to say that somehow, well, if it wasn't for her, I wouldn't have done this, or she's the one that did this. At the trial, well, at her order, he kept saying it over and over and over again as it just keep underscoring the point. And if that had been an isolated incident, if that had been one or two of these things, if that had been a punishment that he administered, maybe the court could accept that. But we have an individual who was in a household for 6 months, intentionally himself engaging in torture of another person. And he doesn't, well, I'm worried about my mom's gonna say, clearly it's not borne out in these reports. He had the ability to disobey his mom. In fact, he was on the stand and almost boasted that, well, I gave him extra food. Well, weren't you worried about how your mom was gonna be upset? I still gave him extra food. So what that tells me is that this has been a careful, manipulated story by Mr. Ferguson from the very beginning of this thing, that he's going to put the blame on his mom. I'm going to be manipulated. I have Asperger's syndrome. I have autism. I have Stockholm syndrome. There's mention of him saying, well, maybe I have Stockholm syndrome in here. No, this is an individual. What the truth of this is that we have two individuals that lack empathy, who lack emotion. And both of them, the triggering factor in this report, the triggering factor that caused this abuse was the removal of the husband, of stepdad. Once he was gone, these two individuals were free to torture somebody, and they did it. That's what they did. And I think Ms. Vander Ark did use Mr. Ferguson. I think that she knew from his history that he was predisposed to torment Timothy. I think that she knew that he would have no problem doing that. And Mr. Ferguson walked through that door and was happy to be the enforcer, was happy to do it, and continued to torture his brother over and over and over and over until he was a shell of a person, until he was dead, died from starvation, died from hypothermia. He had no fat on him, barely any muscle on him. And the whole time, just letting it happen. The report says it appears that the stepfather's presence in the home had prevented Paul and his mother from abusing the victim. Again, it wasn't anything to do, they were just holding him back, essentially. The overall opinion, which I think is important, is, in my opinion, although a defendant's participation in the abuse was in a part a function of his social milieu and living situation, these contextual factors were not a necessary condition for his participation. As previously noted, mental health records contain information to the effect that while they were still living with their father and stepmother and reportedly had no contact with their mother, Mr. Ferguson's stepmother told the psychiatrist that he has become bossy, telling his sibling what to do, and the defendant himself that he would become irritable due to his younger siblings not listening. He gets physically aggressive, told his younger sibling. He also reports that he's gotten irritated with his siblings and has pushed them in retaliation. He's also tried to lock his younger brother, the decedent, in the closet because his brothers wouldn't listen to him. Consistent with this, Norton Shores Police Department documents indicate that Mr. Ferguson's stepsister told police that, quote, he is the biggest bully she's ever met in her life, and he found genuine joy in tormenting Timothy whenever possible when they were living in the biological father's home. Notably, the defendant allegedly engaged in this abusive behavior despite there being any safety rules in place, and despite his father and stepmother disapproving of this behavior to such an extent that they removed him from their home once he turned 18 because of it. In my opinion, Paul Ferguson was predisposed to abuse his brother independent of his mother's present and active influence in his life. Nonetheless, in my opinion, Mr. Ferguson's involvement in repeated acts of abuse that amounted to physical and psychological torture over a period of months reflects a general lack of empathy for his brother and a lack of remorse for his actions. It concludes that, in my opinion, there is no reason to believe that Mr. Ferguson's conduct disorder has remitted or that his participation in the abuse of his brother was not an expression of a persistent pattern of antisocial conduct. The court is concerned that Mr. Ferguson will not get the help he needs in prison. I think he's one step away from becoming a psychopath like his mother. And the court is concerned that he represents a danger to the public. That if released, he would represent a significant danger to the public. The charge here is child abuse. And I don't think this charge or the sentencing guidelines take into adequate consideration of the long sustained torture in this case. As I indicated in Ms. Vander Ark's testimony, there was a long period of months of various punishments, including bread with hot sauce. There's the hot sauce that apparently contains 2 of the hottest peppers that we have in the world. Wall sits for an individual who practically had no muscle left. Running up and down stairs, cleaning out a garage with no pants on, sleep deprivation in itself. Putting alarms on him so he couldn't move or sleep. Making him puke up food. There's bathroom timers. Sleeping in the closet with a tarp down. Which, quite frankly, might be considered animal abuse. But we have a human being here, making his hands over his head. And then at the end of his life, an 8-hour practically ice bath that killed him. So no, I don't think any of those things are adequately taken into consideration by the guidelines. And I don't think the guidelines, quite frankly, these guidelines don't justify Mr. Ferguson's actions. Mr. Ferguson, I think you are a product of your environment, but I don't believe you that you're sorry. I don't. I don't think you have empathy. I don't think you have any emotion whatsoever. And that's what scares the court. It really scares me. I think you're sorry that you're here. I think you're sorry you got caught. I don't think you wanted Tim to die either, like your mother, because you would get caught and you wouldn't torture him anymore. And believe me, I've tried to sit here and try to think, well, maybe Mr. Ferguson's not as bad as Mom. I think you're just as bad, if not worse. If not worse. Because you had a job. You could have, Mr. Johnson actually asked you, couldn't you have brought home a thing of food for him? You could have gone to a neighbor and said, hey, my mom's abusing him. You could have grabbed him and got him out of there. You could have done any number of things to stop this, and you chose not to. Your own brother. And this is where we're at. So, based on all that, It's a sentence of the court. You serve 30 years to 100 years, Michigan Department of Corrections. Credit for 592 days you've already served. Court's going to assess a $68 state cost, $130 crime victim rights assessment. No additional fines and costs. Mr. Ferguson, you have a right to file an appeal in this case. If you're financially unable to retain an attorney, one will be appointed to a public expense. Request for the assistance of a lawyer must be made within 42 days from today's date. Clerk is handing you a form that you must complete. Return to the court in that 42 days if you wish to request the appointment.
Whoa, the judge not mincing words there, telling Paul Ferguson he is one step away from becoming a psychopath, saying that he sees him as a danger to society. And when compared to his mother, the judge said, I see you as just as bad, if not worse, because Timothy was in his care. He was the one day to day caring for Timothy and could have flagged it for police, could have put a stop to it, could have done something, but he chose to do nothing and go along with his mother's bad behavior. Wow. The judge launching him 30 to 100 years. Oh boy. Oh boy, were you expecting this? That is a hefty sentence for a young man. Let me bring in my guest now, see what he thinks of this. He is a retired NYPD sergeant. He's the host of the podcast True Crime with the Sarge, Joe Giacalone, on the show with me this morning. Joe, good morning to you. What'd you think of what the judge just did?
Yeah, I think he was spot on. I mean, when you hear about the torturing of animals and all the other things that are going on, I mean, this is like the definition of what you're dealing with of a future serial killer. And to be able to do this to your own brother and to be able to, you know, basically go along with the program. I mean, I know people say that, you know, he was under the mother's, you know, evilness and everything else that goes along. Yes, but you know what? That Nuremberg defense doesn't work, right? I was only doing what I was told. And if you don't know your history, we're doomed to repeat it. And this is just something that you have to look at in the sheer depravity of this act, and to be able to do this to anything, let alone your brother, is just, it's just one of those things where it just makes you nauseous. That's about the only word you can think of.
Isn't that the truth, Sarge? I know it is. It is nauseating thinking about the facts. And how about when Shonda Vander Ark feigned the nausea? I'll never forget that, when she was on the stand and she appeared to be stunned at the photos of her son, as if she didn't know what little Timothy looked like when she was starving him and abusing him and torturing him for all those years. My goodness, justice has been served for both Shonda Vander Ark and her son, Paul Ferguson. Oh boy, 30 years. I'm sure we're going to see an appeal, but we'll leave it there for now. We'll see if there is an appeal or anything that is even an appealable issue. He pleaded here. My goodness, 30 years. Joe, do you think he's going to fare well in prison? What do you think about how this kid may handle himself? And I say kid, he's a young adult. He's a young adult. I am not calling him a kid. Don't anybody tweet me and say I have no sympathy for this guy, believe me. But he's young. We know that this all started when he was a teenager. He's an impressionable young adult. I would imagine prison is going to be horrifying for him.
Yeah, I think the evil that he awaits for him is going to be immeasurable to him. I mean, some of the things that he did to his brother, there's a likelihood that they're going to do to him. I mean, he's not a imposing figure at all. And, you know, listen, the word gets back to the prisoners before we even know these things. They have the TV, they have the internet, they know exactly what's going on. You know, when you see what the torture was like, and you're dealing with a prison system where there are people who are worse than he is, unless they keep him in solitary confinement the rest of his life, he's going to have a very difficult time.
Isn't that the truth? Sergeant Joe Giacalone, so glad you're on the show today. We've got lots more to talk with you about. We're going to talk about the Boston case involving defendant Karen Reed. She's accused of murdering her police officer boyfriend. Officer John O'Keefe is the victim in this case. And Karen Reed is due in court at 2 p.m. today. Now, her defense team is asking for the charges to be dismissed. The state has fired back with a motion that includes never-before-seen evidence, evidence that the grand jury saw in indicting Karen Reed. It is very, very damning. We're going to go through it next. We've got a live report with Matt Johnson coming right up. Also, we're getting ready for the start of the case in New Mexico against Rust movie armorer Hannah Gutierrez. Don't go away.
A masked hero, a faithful sidekick, a trusty steed,
Silver!
and a boundless trail of blazing adventure.
So you're the masked man? I'm afraid so. Coming after you.
Thundering its way into our weekday lineup.
This mask stands for justice. Come on!
The Lone Ranger, Wednesdays on Grit Extra.
We'll be waiting for them.
Television with backbone.
Ion Plus is your home for adventure,
Rex, go!
mystery,
Fascinating.
and thrill.
Woo!
Just keep your ear out and see if we pick anything up.
What's with the dog?
He's with me.
You're not supposed to root for the criminals.
That's what I do.
No crime is unsolvable. Some simply take longer than others.
You'll always find more on Ion Plus.
Let's gear up.
I'm in position.
NCIS, open up.
We got a runner! I got him!
Party's over.
It's over.
It's over.
It was the case that started America's true crime obsession.
My office filed murder charges against O.J. Simpson.
A fallen star, a dream team of lawyers, and all the dramatic courtroom moments that have become legendary.
If it doesn't fit, you must acquit.
Relive the trial that had the world watching.
And made court TV a legend.
The trial of O.J. Simpson. Weekdays noon to 4 on Court TV Legendary Trials.
Let's go. Really? That is incredible.
It's the best job in the world.
And that's saying a whole lot.
We have evidence of that.
Absolutely. That's good news.
My curiosity is piqued. Pretty much sums it up.
100%.
At Scripps News, reporting your world from the middle matters. Since 1878, Scripps has been a shining light in the middle of the storm.
Stories of survival and hope.
In the middle of the action.
You can see how treacherous the terrain is here.
The middle of it all.
This is a story that began long before.
So when events unfold on every side, see it clearly from the middle. Scripps News. Find with an antenna or on your favorite streaming app.
Welcome back to Court TV Live. I'm Julie Grant. We're looking ahead to 2 motion hearings coming up in this afternoon. In the case involving defendant Karen Reed, new court filing points the focus back at her and her defense team debunking the theories that they floated out publicly. The state saying they have DNA evidence implicating Reed in the murder of her boyfriend, Boston police officer John O'Keefe. Let's talk more about this. There's a lot here. So essentially, the defense is filing a motion saying dismiss all the charges against our client. There just isn't a basis. The state fires back with a responsive motion. It is 49 pages. I read it all twice. The state doesn't hold back. They share a large amount of the evidence that the grand jury got to consider in indicting Karen Reed. And this is evidence we haven't heard before publicly because prosecutors have different ethical constraints than defense attorneys. Defense attorneys in the private sector can stand on the courthouse steps, as we've seen these attorneys do. They've been fiercely advocating for their client, floating out their theories about a party, a fight, and a dog bite. And the state can't respond, but they can in the form of a motion. So I'm wondering if the defense has any regret in this motion to dismiss. Let me bring in someone who is very much in the know on this case. He's covered it since the inception. Court TV crime and justice correspondent Matt Johnson back at headquarters. Welcome back.
Nice to see you. Thank you.
You too. Great job on the Montgomery case, and now we're turning fast to this one. Big hearing today at 2. What do we expect to happen today, please, Matt?
It's interesting because at the Montgomery case, everybody was talking about this next upcoming case in that area. This is only about an hour away from where that trial took place. So today is going to be a major day. Expect fireworks there in the Boston area in Dedham today, Julie, because today, yes, it's the motion to dismiss, but this is what was left on the docket after both sides have been asking the judge to push this trial because they are still getting discovery in this case, according to what I've been told. So we are about a week away from when this trial is supposed to start in March 12th of this year. So, I mean, this is going to be a big day to determine whether or not that still happens, if this gets pushed, and then what else might we find out, right? Because we still don't know what information could be on Karen Reed's phones that were taken from her premises. I don't think that they have a search warrant just yet to unlock it, and, you know, there could be more with the federal probe. We don't have all of the details with that either.
Right, right. So still many outstanding questions, which is a great point. Some of the details in this motion are really illuminating. Let's talk, if we can, a little bit about them. Could we start with motive, how much of what's in this motion really paints a picture that was very bad with this relationship between John O'Keefe and Karen Reed, Matt?
Yeah, and how they're putting it in this court documents that we're bringing to you, romantic entanglement with Karen Reed and one of John O'Keefe's very good friends that was there partying with them. Remember, they went to a series of bars. Everyone, they're not, you know, saying that they weren't. They were very drunk. They were drinking a lot that night, and they were drinking with friends. And Brian Higgins is a man that they were drinking with, was at these places. And, you know, prosecutors are saying that there's a motive here because neither one was faithful at this point in time in their relationship when our victim dies in all of this, however he dies. But so we have Brian Higgins that is now saying in these court documents that Karen Reed was making passes at him and kissing him just feet away from where they were at a party with John O'Keefe, you know, her current boyfriend.
Right.
And John O'Keefe, she claims, the prosecutors say that John O'Keefe may have made a pass or kissed a woman when they were on vacation in Aruba. So creating this firestorm in their relationship and how that could be motive if there was unhappiness. And also they're saying in these motions that she was leaving very disturbing voicemails. Right. Karen Reed was screaming at him. So trouble in paradise.
Big time, Matt. So that's the backdrop, the context at this time in January of 2022 when John O'Keefe is killed. Some big forensic evidence has come out in the form of this motion. The state just responding. The defense said, you have no evidence. And they said, oh boy, yes, we do. Let's take these things one
We need some. Is he getting the earphones? Okay. Calling is D101CR 2023-40, State of New Mexico versus Hannah Gutierrez. Parties state their name.
Carrie Morrissey and Jason Lewis on behalf.
Monica Barreras, Carmela Cisneros are here with Ms. Gutierrez Reed.
All right, thank you. All right, is this your next witness?
This is.
All right.
Good.
The state calls Bryce Ziegler.
Face the judge and raise your right hand.
Do you swear affirm under penalty of law that the testimony you'll give in this case will be the truth, the whole truth, and nothing but the truth?
I do.
All right, have a seat, talk into the microphone.
Mr. Ziegler, is your microphone on?
Yes.
Okay. Mr. Ziegler, go ahead and just state your full name for the record.
My name is Bryce Ziegler. First name spelled B-R-Y-C-E. Last name spelled Z-I-E-G-L-E-R.
Mr. Ziegler, how are you currently employed?
I'm currently employed by the Federal Bureau of Investigation within the Laboratory Division, specifically within the Firearms and Tool Marks Unit.
Can you give the jury a summary of your educational background and training?
I received a Bachelor's of Science in Forensic Science from the Pennsylvania State University.
And how long have you worked for the FBI?
Since the summer of 2011.
And since 2011, what positions have you held at the FBI?
I was initially hired into one of the DNA units at the laboratory, and I essentially worked as what's called a technician in that discipline. So I essentially did the majority of the DNA processing operations, but then a examiner would come in, review my work, review the profiles, and take it from there. In 2015, I transferred to the Firearms Tool Marks unit, which is where I am now, and I was also promoted to a forensic examiner. So in this current position, I receive evidence that's related to my discipline. I perform the requested examinations on those items of evidence, and I issue the results in a formal laboratory report. And also, if I'm called to, I can testify to those results.
And, sir, other than your undergraduate degree, what kind of training do you have in the area of firearms and tool marks?
In order to become a qualified forensic examiner in this discipline, I had to complete what's called the Forensic Examiner Training Program. And that program, it's developed and implemented by the FBI lab, and it's specific to each particular unit. So I had to complete the program specific for firearms and tool marks. And this program, so I was assigned a mentor, and I was also given a training manual. So this mentor kind of guided me through the process, reviewed tasks in that training manual with me, and to essentially complete that process, I had to pass a series of written examinations, oral board exercises, practical competency tests, as well as moot court exercises.
Thank you, sir. And have you ever been qualified as an expert?
In court?
In court, yes.
Yes, I have.
And in what areas have you been qualified as an expert?
Some of those are general firearms examinations. Sometimes it's firearms identification, so that's the microscopic comparison of fired ammunition components back to firearms. I've also been qualified in shooting incident reconstruction.
And in terms of shooting incident reconstruction, did you do that kind of work in this case?
No, I did not.
And I apologize, we were having a technical difficulty here. In terms of the work that you did on this case, what areas of expertise have you been qualified as an expert in that apply to this case?
Sure. I would say those two areas are the examination of firearms and also firearms identification.
Okay, thank you, sir. We will ask the court to recognize, well, you know what, let me pause. Have you testified before?
Yes, I have.
And have you been qualified as an expert in other courts?
Yes, I have.
And how many other courts have qualified you as an expert?
13.
And are those all federal courts or state courts?
10 of those are federal, 3 were state.
Okay, thank you. I would ask the court to recognize Mr. Ziegler as an expert in firearms examination and firearms
Identification.
Thank you, identification.
All right. You are recognized as an expert in examination of firearms and firearm identification.
Now, it's okay, thanks, you can have a seat. In this particular case, were you provided certain items of evidence for testing?
Yes, I was.
And approximately how many items of evidence were you provided for testing?
That's difficult to approximate because I was given a certain number of item numbers, but those item numbers may have, for example, 30 cartridges. So I believe that item numbers, I would say maybe around 50 items, but again, that could mean a much larger set of items.
Were you provided a firearm to examine in this case?
Yes, I was.
And did you have any understanding where that firearm came from?
I don't have personal knowledge of where the items of evidence are submitted from. They are generally submitted with some information that gets populated into our laboratory database. So I do have a description of that. That information gets populated into my lab report, but I don't have direct knowledge of where those items came from.
So what was your understanding, and I appreciate your qualification there, what was your understanding of where the firearm in this case came from that you administered some testing on?
So in this case, it was just labeled as a revolver. There was no description as to, for example, no address where that firearm was collected from.
You weren't given any information about whether it was collected from a movie set or whether it was a prop being used by an actor?
Your Honor, I'm going to object to leading.
Actually, I don't think that is leading.
Overruled.
I don't have that information.
Okay. I'm going to show you, whoops, what I have marked as State's Exhibit 97. May I approach? Do you recognize that?
Yes, I do.
What is
Your Honor,
that?
may I see that?
Mr. Ziegler, what did I just show you?
That is a photograph of the revolver that was submitted to my laboratory for examination.
Is this a revolver that you did testing on?
Yes, it is.
Your Honor, I'm going to move for the admission of State's Exhibit 97 and ask for permission to publish.
No objection.
All right, States 97 is admitted. You may publish. It was on my screen before.
And can I ask, is there any way for me to only publish to that monitor so that I don't have to walk back and forth? Just to his monitor so that it only goes to his and doesn't go to everybody else's when I'm going through the exhibits.
No, if it's You mean to recognize it?
Correct.
We would have to keep turning it on and off.
Okay.
Or else you could, yeah, that's what we'd have to do.
Okay. Why don't we just take a minute and let me see if I can get an agreement so that we don't have to do that.
Okay.
All right.
Great.
The state will move for the admission and permission to publish throughout Mr. Ziegler's testimony of States Exhibit 97, 97A, 98, 99, 100, 101, 102, 103, 104, 105, 106, 107, 108, 109, 110.
So is it 97A through 110? Did you skip anything?
97, 97A, and then 98 through 110.
Any objection? All right. States 97 through 110 are admitted.
Every time we unplug it. All right, Mr. Ziegler, can we go ahead and put it up on the screen?
Yes.
Mr. Ziegler, tell us a little bit about this firearm that was provided to you. What kind of a gun is it? And just generally speaking, how does a gun like this operate?
So this is an image, a photograph of the revolver that was submitted. And this is a single action revolver. So that means that the hammer must be manually cocked by the shooter every time that the shooter intends to fire. So some revolvers, if you pull the trigger, it will do the work of cocking the hammer for you and releasing the hammer. This type of firearm does not have that ability. The shooter must physically cock the hammer each time. Is this a touchscreen by chance?
Yes.
Okay. So to point out a few key areas of this firearm, the portion on the left, don't believe him.
He's going to come help you.
Okay. Thank you. So the portion on the left in this photograph is the barrel. Towards the center, we have the cylinder. This back portion here is the hammer. We have the trigger near the bottom. And this wooden piece is the grip. So this is where you would hold the firearm. Let me clear this out. So basically, in order to get this firearm to function, you would have to load cartridges into the cylinder. This can be accomplished two ways. You can't see it in this photograph, but on the opposite side is what's called a loading gate. You can open, and you then have access to the cylinder. So you can load each cartridge one at a time, rotating the cylinder until you have as many cartridges as you desire. You could also remove this pin here, remove the cylinder from the firearm, and load it that way. But regardless, once you load the cylinder, you must manually cock the hammer all the way to the rear, and then at this point, this firearm will be ready to fire. So a pull of the trigger would release the firearm, or excuse me, the hammer. The hammer has a firing pin that's fixed to the hammer, so as the hammer falls, the firing pin would strike the primer of the cartridge and fire that cartridge.
Can you give us a quick description about the notches on the hammer and the different hammer positions?
Yes, so as you would cock this hammer, it has several safety notches by design. So as you cock it, you're going to hear a series of clicks, and those are the safety notches. So as you start to cock it, you're going to hear your first click. That's the quarter cock notch. If you continue to cock it, you'll hear your second click. That's the half cock notch. And if you cock it all the way, you'll hear the third click, and that's when it's in its fully cocked position. So those intermediate two cocking positions, they serve to do two things. Number one, when the hammer is completely at rest or not cocked at all, the firing pin actually protrudes inside the frame. So it's very difficult to see here, but in between this gap, between the cylinder and the frame, you would actually be able to see the firing pin sticking out. So as you start to cock it, it starts to remove the firing pin from protruding. So we don't want the firing pin making contact with the cartridges when we don't want it to. So it starts to retract the firing pin, and also if I'm cocking the hammer and my thumb slips off the hammer, you would expect that it's going to catch in one of those two safety notches. So this is to prevent the hammer from falling unless you want it to. So really, this firearm is only designed to fire when the hammer is in its fully cocked position.
In terms of well, let me ask you this. The half cock notch, so that's going to be the second click that you hear when you're cocking the hammer. Is that correct?
Correct.
Is there anything particular about the half cock position other than it being a safety?
Can you elaborate?
Sure. What position does the hammer have to be in order to load this gun with ammunition?
I understand. So you have to have the hammer retracted to a certain point to allow the cylinder to rotate freely. So there's a part, and it's on the inside here, called the cylinder stop, and that cylinder stop does not unlock until the hammer is pulled back to a certain point. So once it's pulled back to a certain degree, you can freely rotate the cylinder to load it with as many cartridges as you desire.
So in order to load and unload this gun, if you don't remove the pin and remove the cylinder, it has to be in the half cock position.
I'm not sure if it's somewhere between the quarter and the half cock, but it is in that intermediate area, yes.
So once you get it into the half cock position, what do you have to do to load it?
So I'll clear this out. Again, on the other side, there's a loading gate that you can open, and you then have access to the cylinder, so you can load it that way or remove the cylinder itself.
How many cylinder positions do you have access to when you open that loading gate?
Only one at a time, so you must manually rotate the cylinder and continue to load a single cartridge at a time.
So for those of us that are familiar with revolvers where you push a button and the entire cylinder kind of rolls out and you can load and unload that way, does this gun work that way?
No, those are going to be your more modern style revolvers.
If you noticed when you received this gun and you examined this gun, did this gun appear to be very old or relatively new, or were you not able to tell?
I'm not able to tell its age now.
Okay. Who is the manufacturer of this revolver?
The trade name is Pieta. It's an Italian company.
And do you know anything about Pieta and what they do, what they make?
I do know they have product lines they create new firearms that are essentially replicas of older firearms.
Is this a replica?
It's a replica in that it's an old design, but it's still a functioning firearm.
Now, if the hammer, let's talk about kind of hypothetically. Let's assume that this gun is fully loaded with live ammunition. And we have the hammer in its resting position, so it's fully down. Is that the position it's in this photo?
Yes, it appears so.
So how is this gun designed in terms of safety with regard to possible accidental discharges when the hammer is in the fully rested position?
Right, so when the hammer is fully forward, as I mentioned earlier, the firing pin actually protrudes inside the frame. So if you have the cylinder fully loaded and the hammer is at rest on a chamber that has a live cartridge in it, that firing pin is actually sitting on the primer of that cartridge. So if I were either to strike the hammer or if I were to drop it and it landed on the hammer, it's going to fire that cartridge. So if you hit the hammer with enough force, it will detonate that primer in that position. And that's part of the design of this firearm. That's just how these are made. And if you were to look at the owner's manual, which this is one thing I did as part of my exam, you would actually see warnings not to carry this firearm with the hammer at rest on a loaded chamber. So a lot of times it's actually advised that you load one less cartridge in the cylinder. So you have one empty chamber, and that's how it's carried with the hammer forward on that chamber. So these are recommendations in the owner's manual. So this isn't some phenomenon. This is something that's known about the design of these firearms.
And what kind of testing did you perform on this firearm?
So initially I did a function evaluation just to make sure it appeared that, you know, there weren't any odd modifications, that it was functioning correctly. After that, I was requested to do some microscopic comparisons, as I was also submitted a fired bullet and a fired cartridge case. And then the last type of testing I did on this particular gun is what's called accidental discharge testing. So essentially the goal of that test is to see if I can get this firearm to function without pulling the trigger.
So the first set of testing that you mentioned, what did that entail?
So a function examination is basically, I need to inspect the firearm for safety purposes. Keep in mind, I've never seen this firearm before when I first opened the box. So I don't know what condition it's been in. I don't know how old it is. I don't know how well it's been taken care of. So eventually I'm going to want to test fire that gun. So I need to make sure I feel that it's safe to fire, so I don't have some catastrophic failure while I do so. Once I determine that it is safe to fire, I will physically take the gun to one of two locations in the FBI lab, and I will load it with ammunition from the laboratory and actually test fire the gun.
And did you test fire this gun?
Yes, I did.
Approximately how many rounds of ammunition did you fire out of this gun?
May I refer to my report?
Sure.
I physically fired this gun 12 times, so as a result of that, I retained the fired bullet and fired cartridge cases that I produced during that test firing. And I also collected some other cartridge cases as a product of the testing that I did. So these would be cartridge cases that I collected during the accidental discharge testing.
And the rounds that you fired, the 12 rounds that you fired out of this gun, were they evidence rounds, or were those rounds that were supplied by the FBI?
They were FBI cartridges, and then once I fire them in the evidence firearm, they become what's called secondary evidence. And essentially, if I have to conduct microscopic comparisons at a later point, that secondary evidence, they now become my knowns. I know they came from that firearm because I physically shot it and collected those items.
All right, thank you. Tell us about the second group of testing that you did.
Right, that was the microscopic comparisons. So again, I was submitted a fired bullet and a fired cartridge case. And essentially I was asked to determine if, in my opinion, I could determine if those two items were fired by this particular revolver.
Okay, and let me back you up for a moment. Did you examine rounds of ammunition as a part of your forensic examination in this case?
Yes, I did.
And did you examine dummy rounds?
Yes, I did.
Did you examine live rounds?
Yes.
Did you examine live rounds? Well, did you examine live rounds that you understood to be provided by someone named Seth Kinney?
Yes, there were some cartridges that were submitted, and they were declared to be live rounds as they were submitted.
Did you examine live ammunition that came from a location that you were notified was 126 Monroe Street?
Your Honor, I object to leading.
I'm not leading, I'm just asking him a direct question.
May I review my...
Sure.
Thank you. Yes, I do have some item numbers that have that address in their item description.
Did you also examine live ammunition that came from the set of the movie Rust?
Yes, I did.
And when you examined that ammunition, what did that entail?
So the evaluation of the ammunition kind of took place in a couple different phases. So first, I just looked at the physical characteristics. So I evaluated its appearance from the outside. And based on that, I started to segregate these types of ammunition into groups just based on their physical appearance. So I could put them into groups. For example, some of them appeared to be live cartridges, so I had that group. Some of them appeared to be dummy rounds, and so they may have some physical visual clue that they may be a dummy. So for instance, some of them had holes drilled into the side of them. So I could look into the cartridge and see there was no powder present. Some of them, when you shake them, there are actual BBs inside. So that produces an audible indicator that even though this looks to be a live cartridge, in reality, there's nothing on the inside. So I can shake it, and that's another indicator that that may be a dummy. There were a series of blanks, which a blank does not have a bullet. It still has a primer and gas, but it's not meant to actually fire a projectile. So I started to form these groups just based on their physical characteristics. I then x-rayed all the ammunition because I could hear some of these cartridges it sounded like BBs inside when you shook them. So I wanted to get an idea of just a picture of what was going on inside these cartridges. So again, I took those two pieces of information, sorted them into groups, and then eventually I worked with the contributor to determine which of these cartridges actually need to be disassembled. So we can take out the bullet and we can look inside and see, is there any powder present? Does it look like the primer is active or not? So those were kind of the three phases to sort of determine which categories these cartridges actually fell into.
Okay, and quickly I'm going to jump you to the accidental discharge testing that you did. Can you summarize for the ladies and gentlemen of the jury what that accidental discharge testing consisted of and why you did that testing?
Right, so again, accidental discharge, its goal is essentially to determine, can I fire this firearm without pulling the trigger? That's kind of the end goal. And the way we do that is the test is designed to simulate the firearm being bumped or banged into something, just being jostled around, and seeing can those kind of interactions fire the firearm. So the way we replicate this in the laboratory is I will take the gun and actually strike it with a rawhide mallet on 6 planes. So if you picture a box sitting in front of you, the 6 planes would be the front of the box, the rear of the box, the left side, the right side, the top, and the bottom. So those are the 6 planes. So if you kind of picture the revolver and picture how those 6 planes work around that gun, I'm going to go around and strike the firearm in all 6 of those planes with a rawhide mallet. Again, trying to determine if it will actually fire without me touching the trigger.
And specifically, when you're striking the firearm, are you striking the hammer?
That was a part of the testing that I did, yes.
Prior to conducting that testing, did you have any thoughts about whether that could potentially result in damage to the gun?
Right, so this is actually in our standard operating procedures, that this type of testing is potentially destructive to the firearm. So just kind of generally speaking, if I'm going to do an exam that may destroy or alter the evidence permanently, I would seek out the contributor's permission to do that exam before I actually go and do it. So that is what was done in this case.
So you obtained permission to proceed with that testing,
That's correct.
understanding that it could result in damage.
Yes.
All right. Let's go ahead and, let's go ahead and just briefly describe the striking of the mallet and whether or not at some point there was damage and kind of what you learned during that test.
So as we're doing this test, we want to test the firearm in all modes of fire that it's capable of. So if I have a rifle, for instance, and say it's semi-automatic and fully automatic, I would do the test in both of those settings. In this case, completely different type of firearm, but I wanted to test this gun in all 4 positions of the hammer. So at rest, quarter cock, half cock, and fully cocked. And essentially as a result of that testing, there were only 2 times that I was able to get this firearm to fire. The first one being when the hammer was at rest on a loaded chamber. So as I previously described to you, the firing pin was sitting directly on the primer. So when I struck the hammer with the mallet, that provided enough force to detonate the primer. So again, that's a known feature of this type of firearm. The second test where this occurred was when the hammer was in the fully cocked position, and I was doing my striking in the 6 planes as I described, and eventually I got to the rear of the firearm, so that back plane, and eventually at some point I struck the hammer with a rawhide mallet, and the hammer actually fell and it detonated the primer. So what happened was some of the internal components of the firearm actually broke to allow that hammer to fall and fire the primed cartridge case. So I previously mentioned those quarter and half cock notches. If the hammer were to fall and there was no damage inside the gun, I would expect that the portion that makes contact with the hammer is called the sear. That sear should have been caught either by the quarter or the half cock notch as the hammer was falling. It should not have been able to fall all the way. So this is what led me to believe that there was some type of damage that occurred within the gun. And eventually I disassembled it to figure out exactly what that damage was.
So the damage that you discovered, just so we're clear, was that damage sustained at the FBI lab?
Yes, it was.
Based on the testing that you did, when this gun was received by the FBI, was it in proper working order?
Yes, so the first exam I did was the function exam. So again, that's making sure it's operating correctly and that it hasn't been modified. During that test, I also examined the safeties. So as it was received in that condition, when I went through the function evaluation, everything appeared to be operating correctly. So it functioned normally as it was designed.
So you were able to make it fire in the resting position, correct?
That's correct.
And then did you put it in the quarter cock position?
Yes.
And did you strike it with a mallet?
In that particular case, for the quarter as well as the half cock, I did not need to do the mallet testing.
What kind of testing did you do?
So the quarter and half cock notches, are not designed to essentially lock the trigger or put your firearm completely in a safe setting. So again, they're designed that if your finger slips off the hammer, it's going to catch it. So in this type of gun, if your hammer is in either the quarter or the half cock, you can actually squeeze the trigger, and if you squeeze it hard enough, it's going to cock the hammer enough that it releases. So you can still make the hammer fall, even though it's in these two intermediate safety positions, if you apply sufficient pressure to the trigger. So I did a variety of testing to determine if I put the hammer in the quarter cock as well as the half cock notch, and I squeeze the trigger hard enough that I allow the hammer to fall, is it even feasible for the hammer to detonate the cartridge? And I determined in both of those positions it was not.
And we understand that the next testing that you did was in the full cock position.
That's correct.
And ultimately, as you predicted, was the gun damaged?
As a result of the testing, yes, it was damaged.
Okay. Let's move to State's Exhibit 97A. Can you tell us what we're looking at here?
Yeah, so this is a photograph that I took after the accidental discharge testing was complete. So on the right-hand side, we have the hammer. As I mentioned before, the firing pin is fixed to the hammer, so that's that piece that you see protruding from the hammer. In the top left, this piece is called the cylinder stop. So you can see a piece of that component fractured off. The bottom left here, we have the trigger, and this tiny piece here is what actually fractured off the trigger. Now, as I mentioned before, I explained the quarter and half cock notches, so I'm actually going to point those out to you. On the hammer, these kind of jagged edges, the first one is the quarter cock notch. So as you're cocking the hammer, you hear that first click. That is the sear portion of the trigger, which is now broken, locking into that little recess. Your second click is the half cock notch, so that's that second jagged edge. And then your last click is the actual sear notch. So that's where the trigger is sitting when the hammer is in its fully cocked position. So when I struck the hammer with the mallet, it actually broke off that piece of the trigger that was sitting up against the hammer there.
And is there anything unusual to you in this photo about the full cock notch on the hammer?
So again, this notch here is the full cock notch. So you may notice when looking at this that this notch appears much flatter when you compare it to the other two notches. So it could be that a small portion of this surface was also damaged during the testing. But in addition to that, there are times where the sear notch is just not as pronounced as the other two notches. So I didn't observe any damage myself in this particular area, but it's possible that that area was damaged as well.
And based on your testing, did you form an opinion about whether or not this gun could be fired without the handler pulling the trigger?
So again, the only two times that occurred was with the hammer at rest on a loaded chamber, and the second time I attributed this to the breakage of internal components. So again, if these parts had not broken, I would expect that the trigger should have been caught by either the quarter or the half cock notch as the hammer was coming forward. So I would not expect this to occur had this breakage not happened.
So just to be clear, did you form an opinion about whether the handler would have to pull the trigger of the gun to make the gun fire?
My opinion is that the only reason this occurred is because of the breakage. So in order to move the trigger away from the hammer, that's typically accomplished by pulling the trigger. So in this case, the only way that was possible is because the trigger actually fractured.
Okay. So in order for you, just so that we're clear, in order for you to make the gun fire without pulling the trigger, when it was in the full cock position, you had to break it.
That's what I had to do in my lab. I can't account for all the other possibilities that may have existed in, you know, some hypothetical scenario, but this is the result as I tested it in my laboratory. It would not fire without pulling the trigger in the full cock setting without being broken.
Thank you. Let's move to State's Exhibit 98. Can you tell us what we're looking at here?
Yes, this is a photograph of the fired bullet that was submitted for comparison.
And can you describe to us in a little bit more detail what we're seeing in this photo?
This is the lead bullet that was submitted. It's very damaged. So typically when I look at a fired bullet, I would expect to see nice areas that are engraved with the negative impression of the barrel. So I'd expect to see, for example, deep lines that define what we call the rifling. And in this case, I don't see that. I just see a series of abrasions on the outside of this bullet. So essentially, whatever this bullet came into contact with, it basically damaged the exterior surface so greatly that the information that was left behind from the barrel is gone.
When you're talking about what the bullet came in contact with, I just want to be clear, are you talking about what the bullet came in contact with after it left the barrel of the gun?
That's correct.
State's Exhibit 99. Explain to us what we're looking at here.
So these are just additional images of the same fired bullet. So I took these using my microscope, so they're a little bit higher magnification. And basically, in both of these photos, the bullet is pointing to the left. So you're looking at the image of the left, you're looking at all of the damage and abrasions that were present on that bullet when I received it. And the image on the right is similar to the one you saw on the previous slide, where it doesn't have the deep gouges in different directions, but the rifling is still virtually gone from this bullet.
Can you tell us what caliber this bullet is?
When we receive fired bullets, the only way we can estimate the caliber is based on the diameter, so I can measure the diameter of the bullet, and also the bullet weight. So for those two items, they were very close between a .44 caliber and a .45 caliber bullet. So I classified it as either a .44 or .45 caliber bullet.
Can you explain to us why a .45 caliber bullet, by the time it gets to you, may have a different diameter and weight?
Sure, so this projectile is lead, which is a relatively soft material. Most modern bullets are going to have a harder jacketing material, so it's going to have a lead core with a harder jacket around it. The most common type is going to be copper, and that harder material is going to protect the lead core. It's going to help it keep its mass as it starts hitting things. But because this is lead, it's relatively soft, it's much more susceptible to damage when it hits things. So it's possible that when I receive a bullet or even a bullet fragment, and I go to take a measurement of that bullet, it may be less than the true measurement because it's hit things and I now only have a partial bullet. Or conversely, it could actually be a wider diameter because it hits something and it flattens, so that causes it to expand. So that's why when I'm taking that measurement into consideration, I may not be able to narrow it down to just one specific caliber.
And State's Exhibit 100, what's this?
These are two images of the fired cartridge case that was submitted for the examination. So the left image is from the side, And the right image, you're looking at what's called the head stamp of the cartridge. So the head stamp itself is the outer ring where you're going to see information such as the caliber. So 45 Colt is the caliber. You may also see symbols which relate to the manufacturer. And then this silver colored surface in the center here is the primer that I've been talking about. So this is what the firing pin comes into contact with when you pull the trigger. So this crater in the center, that's the firing pin impression. So when the firing pin falls, strikes the primer, it leaves behind an impression of the firing pin. And also during the firing process, the cartridge case rests up against a flat surface called the breech face. And during the firing process, this cartridge case slams into the breech face and it can pick up an impression of imperfections on that surface. So you may see some parallel lines. Some of these lines are kind of arcing. They almost appear to be crosshatch. Again, there's more parallel lines on the left here. That's an impression that this cartridge case has picked up from the breech face of the firearm.
Did you compare this casing with anything else, any other casings?
This was the only fired cartridge case that was submitted, but I did compare it to those known specimens that I collected from the revolver that was submitted.
And the known specimens, are those the ones that you fired out of the revolver yourself?
That's correct. That's the secondary evidence that I spoke about earlier. So I created that evidence in the lab by physically test firing the gun, and they became my knowns at that point.
Did you form an opinion about whether or not this cartridge casing was fired from the gun that we saw in the earlier exhibits?
Yes, it's my opinion that I identified this cartridge case as having been fired by the revolver.
State's Exhibit 101. What are we looking at here?
So these are representative images of the comparison that I did to get to that conclusion of identification. So if you look at the image on the left, this is two cartridge cases being compared side by side, and this is on my what's called comparison microscope. So at the laboratory, I have this microscope. I can mount two specimens. There are two separate microscopes connected by an optical bridge, and there's a binocular eyepiece at the top. So when I look through that binocular eyepiece, I can see images of both specimens side by side. So in the left image, there's this black line running down the center. That's what separates the two cartridge cases. So on the left side, you can see my notes at the bottom here, F item 2, that's my annotation for that came from item 2, which is the revolver. So those are my knowns. On the right side is item 3, so that's the cartridge case that was submitted. And in the photo on the left, I'm comparing those breech face marks that I spoke about earlier. So the impression of that flat surface, I'm looking at the parallel lines as well as the crosshatch lines. And the image on the right, I'm looking at the features down within the firing pin impression.
Thank you. State's Exhibit 102. What's this?
These are 4 cartridges that were submitted for examination.
When they were submitted to you for examination, were you given information about where they came from?
Yes, I do have that information that's been populated into the database.
And if you would tell us, just so that we know what your understanding was, just going to state of mind.
Right. It appears 3 of these were taken from the top of a cart, and the 4th was located in a holster inside a building. Those are the descriptions that I have.
Did you conduct any testing on these cartridges?
Yes, I did.
Tell us about that.
So the process that I spoke about earlier, first I just examined the physical characteristics of these cartridges. I then x-rayed them to see if I could learn anything more about the inside. And then the last step was to actually disassemble these cartridges.
And After going through all of that, did you form an opinion about whether these cartridges were dummies or live?
So these cartridges contained the 4 components that are required to be live functional ammunition. So that being the cartridge case, the bullet. In the bottom here is the primer, which you see in the center of the photograph on the right. And inside the cartridge case is going to be powder, which is the propellant. So these 4 cartridges had all 4 of those main components, which are consistent with being live ammunition.
Is there writing on the head stamp of that bullet? Or the cartridge, rather?
Yes, it's the head stamp of the cartridge. Again, so this is the bottom of the cartridge. It has the caliber and these kind of flower type logos with a line indicate the manufacturer of the cartridge case.
And did all of these cartridges have that same indication on the head stamp?
Yes.
Did all of the cartridges have the same color primer?
Yes.
Did all of the cartridges have the same shape projectile?
Yes. So you can see in the image on the left the shape of the bullet here, as well as the color, the finish of the bullet. So these are what are called lead flat-nose bullets.
State's Exhibit 103. What are we looking at here?
This is a photograph of essentially a box of ammunition that was submitted to the lab. So on the right-hand side, you see information that's present on the exterior of the box. And on the left-hand side is the foam tray that's inside that box, as well as the cartridges that were inside it.
When this photo was taken, if you can tell us, had the order of the cartridges in the styrofoam insert been modified?
Yes, so generally a box of ammunition comes in with 1 item number. And when I opened it up, I saw various things, various calibers, various types of bullets. So I started to form groups based on what was in that box, and then I gave them their own sub-item number. So for instance, I believe this was item 13, and I divided them based on the physical characteristics that I was seeing.
So the cartridges are in different positions in the styrofoam insert in this photo than they may have been at the time they were taken into evidence.
That is possible. I'm not sure what positions they were in at the time it was opened.
And did you do any testing on these cartridges that were in this box?
Yes, I did the same series of testing that I've explained before.
And can you summarize for us what was in this box based on your examination and testing?
May I check my notes? Just
Certainly.
double check. So the vast majority of the cartridges that were in this box were dummy cartridges. And some of them had visual indicators. As I mentioned before, they may have a hole drilled in the side, or you could shake them. And again, that's an audible indicator. However, there was 1 cartridge in this box that, again, it had the 4 components required to be live ammunition.
And when you're looking at this photo, can you identify the cartridge that you believe was determined to be live?
I believe it was this one here with the silver primer.
Thank you. State's Exhibit 104. What's this?
This is actually 2 additional images of that cartridge that I just pointed out on the screen. So this is a side view of the cartridge on the left and an image of the head stamp region on the right.
I want to talk to you about the characteristics of this cartridge compared to the 4 live cartridges that we saw earlier. Does this cartridge have the same shape projectile or bullet as the other 4?
Yes, it does.
Does it have the same indication on the head stamp?
Yes,
And does it have the same color primer?
it does.
State's Exhibit 105. Can you tell us what we're looking at here?
These are images of additional ammunition that was submitted for examination. And these, some of the ammunition came in being declared as live ammunition. So these are images of some of those cartridges that were submitted.
So these are all live?
They were described as being live, and they had the physical characteristics of being live.
Based on the information that you received that went along with these cartridges, where did these cartridges come from?
May I refer?
Go ahead.
These cartridges are described as having been, or excuse me, as having come from Seth Kenny.
And do these cartridges, are they different than the live rounds, the 5 live rounds that we've seen photos of previously?
There are some differences, yes.
What are those?
So I see differences in the morphology of the bullet, so the shape of the bullet. For instance, this first one in the top left, this is actually a nickel-plated hollow point bullet, so it's not the lead flat nose that you previously saw. The images below that, these bullet types are semi-wad cutters. So again, it's just a different design of bullet, so it's different in shape than the ones you previously saw. You also see additional head stamps here, such as Winchester, GFL, which is a trade name called Fiocchi, and as well as CBC, which is made by Magtech. And this, due to the glare, it's a little difficult to see in this photo, but I also believe there's differences in the colors of the primers.
And let me ask you, if you were to go to a gun store and buy a box of ammunition, would the ammunition in that box have different shaped projectiles?
No, if I was buying a brand new box of ammunition, you go to Walmart, it's going to say on the outside what those bullet designs are. For example, it may say jacketed hollow point, it may say round nose, it may say truncated cone. So I would expect if I open that brand new box of ammunition, all of the bullet morphologies would be the same.
Thank you. State's Exhibit 106. What's this?
This is another series of photographs of another ammunition box that was scented. So in the top left, you see the exterior of the box. Bottom left, you see that foam insert as well as the cartridges. And then the image of the right, on the right, is just those cartridges being removed from the tray.
Can you tell us where these came from, at least what the description was that was provided to you?
Do you have an item number for this by chance?
I will get you one. $28.
Okay. Item 28 was described as having come from the item 27 tray, which is the tray you see here, which was described as having come from the 26 box. And the 26 box was described as coming from 126 Monroe Street.
In your examination of these cartridges, were you able to make a determination about whether they were live or dummies?
May I refer to this?
Sure.
Okay, so these cartridges were submitted being declared as being live cartridges. So basically, they were submitted, and it was understood that these were live functioning ammunition. So I did disassemble 2 of these just to essentially verify that. And the 2 that I disassembled, again, it had the 4 main components that are required to be live functioning ammunition. So the ones that I didn't, they were described as being live, but the 2 that I did had all 4 components required.
Are there any differences in the characteristics of these live cartridges compared to the live cartridges that came from the set of the movie Rust?
Yeah, so again, in the bottom left, I see differences in primer color. These are brass as opposed to nickel. I can't read the head stamps in this photograph, but as far as the bullets go, these are also different because we have the ones that have this sort of little lip above the mouth. Yeah.
Sorry.
Those are called semi-wad cutters. And the other ones, which you see do not have that lip, these are called truncated cone. So the ones that you previously saw, these are different from flat nose because they don't have the rounded sides. It just goes straight. If you were to picture like an orange construction cone, it just goes straight up to the tip.
States Exhibit 107. What's this? Well, and let's begin with what your understanding was of where they came from.
Again, these were reported as coming from 126 Monroe Street.
Were they provided to you with the understanding that they were presumed live or dummy? What was?
Yes, these were presumed live.
And do you have an opinion about whether or not they are actually live cartridges?
So in this case, I did not disassemble any of these, so I can't speak about what's inside the cartridge. So for instance, does it actually have an active primer? Does it have the propellant? So since I didn't disassemble these, I can't testify that I know what's on the inside. But again, these were described as being live.
And the characteristics of these cartridges, did you find them to be consistent with live ammunition?
Based on my physical observations of the exterior, yes.
And are there differences in the characteristics between these cartridges and the 5 cartridges that were provided to you from the set of the movie Rust?
Yes, it's the same types of differences that we've been discussing. So I see differences in the head stamp, which indicates a different manufacturer, as well as the bullet morphology appears different.
States Exhibit 108. What's this?
These are additional cartridges submitted, and again, these were submitted being declared as live cartridges.
And did they appear to be consistent with live cartridges?
Two of these I did disassemble, so I could verify that they had the 4 components of live cartridges. The rest I did not. So they were physically consistent with being live, but again, I don't have an understanding of what's occurring inside the cartridge.
And same question. Do these cartridges have different characteristics than the live rounds provided from the set of the movie Rust?
Yes, they do. And it's the same. Various head stamps, various primer colors, various bullet morphologies.
States Exhibit 109. Have you seen this before?
Yes.
Is States Exhibit 109 from your notes?
Yes, it is.
Just tell us what we're looking at.
So as part of my examination of the ammunition, I worked with the contributor to figure out which items they wanted disassembled. So I made this chart in my notes. So this shows the images of the cartridges prior to disassembly. The middle column explains the original item number as well as what the item number that I was going to create in order to disassemble a cartridge. And then the last column is just a description of essentially what's left. So for instance, the third row across, item 28 originally was all of those cartridges, but I removed 2, so I sub-itemized 28-1 and 28-2. And then the third column tells you that what's left of 28 is 7 remaining cartridges, and the 2 that I subdivided are eventually what we're going to be disassembled.
And if you already testified to it, I apologize. Did you disassemble all of the live rounds from the set of the movie Rust?
All of the rounds that had the physical characteristics of being live, yes, I disassembled those because I wanted to know if they did or did not have the components on the inside.
Did you take a photograph of the gunpowder that came out of those disassembled rounds from the set of the movie?
Yes, I did.
And did you also take a photograph of the gunpowder that came out of the live cartridges that came from other sources? I think you mentioned Mr. Kenny and also 126 Monroe Street. Did you photograph that powder?
Yes, I did.
And without even using a microscope, did you see differences?
Yes, there were clear differences in both the shapes of the powders as well as the color, which means they may have some different types of coatings on the powder.
Let's move to State's Exhibit 110. Tell us what we're looking at here.
So on the left side, you're looking at a photograph of the powder that was taken from the item 4 cartridge. So this was one that was submitted that was presumed to be live based on its exterior appearance. But once I took it apart, this is the actual powder that I pulled from the inside of that cartridge. And on the right, you're looking at the same thing, but this is from item 24-1, which is one of the cartridges that was submitted as being known to be a live cartridge.
And the powder, I understand on the left we're looking at powder from item 4. Were you able to see the powder from item 5, 6, 7, and 13-1?
Yes, they were all consistent, which is why I only included one photograph, because it would be 5 photographs of the same thing.
Thank you. And I'm going to use briefly a demonstrative aid.
Council, we're going to take our morning bathroom break.
Sure.
Please don't talk among yourselves or anyone else about the evidence received here in court.
All rise for the jury.
All right, you may be seated. Council, approach.
Mr. Ziegler, I just have a couple of final questions for you. Can you see these demonstrative aids that I've put side by side on the screen?
Yes.
And can you see the writing at the bottom, the typing?
Yes, I can.
Okay. So the image on the left, is that an exhibit that we've already looked at?
Yes, we've previously seen this photograph.
And same thing with the image on the right. Is that an exhibit we've already looked at?
Yes.
And I'm sorry, there's that writing that was out of the frame. So I'm going to scroll up here. Is this an exhibit that we've already looked at?
Yes.
Item 13-1, did that come from the set of the movie Rust? I'm sorry. 13-1, did that come from the box that was provided to you?
Yes.
The box of ammunition that we saw earlier?
Yes, this was the box where the majority of the cartridges were in fact dummy cartridges, but this was the one that had the characteristics of being live.
And just comparing the ammunition on the left and the ammunition on the right, can you see distinguishing characteristics, understanding that you cannot see the head stamp or the primer?
Yes, so as we've previously discussed, the bullets are a different shape.
And I'm going to show you State's Exhibit 102 on the left, and those are items 4 through 7. Where did items 4 through 7 come from in terms of the description you received?
Those were the ones that I previously mentioned were from the top of a cart, and with item 7 being found in a holster inside a building.
Do these cartridges that we're looking at on the left and the right, do they appear to have the same shape projectile?
Yes, they do.
All right, thank you. I'll pass the witness.
Yeah. Sir, good morning.
Good morning.
Now, Mr. Ziegler, I want to start with your training with the FBI. As part of that training, were you trained in recognizing dummy rounds?
There were many portions of the training manual dedicated to ammunition, ammunition components. I can't recall if there is a specific task related to dummy ammunition.
And by answering that way, it sounds to me like you were not trained on the recognition and characteristics of various types of dummy rounds, correct?
I don't necessarily agree with that.
Well, do you remember any modules that you were trained on dummy rounds or not?
Not specific, no.
Okay. So you wouldn't know what a Denix round is, would you?
I do not.
Okay. And you wouldn't know a Denix round is from Spain and it doesn't shake and it's a dummy round? You're not aware of that?
I'm not familiar with that.
Okay. Now, also with respect to your training, you were trained in gun safety, correct?
Yes, sir.
And as an FBI agent, you're trained in gun safety, including don't point a weapon at anybody?
I'm not an agent, but because I fire as part of my job, I have been trained in safety precautions, yes.
Okay, sir, and as part of your test firing protocols, I'm sure you observe all those safety. Not to point a gun at anybody, treat it as loaded, keep your finger off the trigger until you're ready to fire. You observe all those?
Yes, sir.
Okay. And sir, you indicated one of your opinions was that your first testing, you determined this gun functioned normally.
That's correct.
Okay. When you were doing that functionality test on the revolver you received, what types of things did you look at on the firearm?
So first I would inspect things like, are there bulges in the barrel, cracks in the frame, things that I may think may lead to a catastrophic failure during the testing.
Okay, sir, do you take that revolver apart in the initial stage?
I do not.
So later on, and I'll come back to this, but you indicated when you hit that hammer with your mallet that it fractured some internal components, correct?
Correct.
And there was the sear, we saw a little piece of the trigger. You remember, sir?
Yes.
Now, because you did not open the revolver prior to doing that hammer test, can you be certain any of those pieces weren't broken before?
I would say I can't be 100% certain. However, because it did function normally, I would expect those pieces were intact at the time I received it and did that initial examination.
Okay, and when you visually examined it from the outside, you then test fired that weapon 12 times, is that right?
As it was 12 times throughout the process, but yes.
And you observed when you did that it had to be fully cocked and that trigger had to be depressed to fire it, correct?
Aside from the hammer being at rest and being struck on a loaded chamber.
Correct. And other than those tests you did, I'm talking about the first part, it fired normally.
Correct.
Okay. Now, after you did that normal gun functionality testing, you determine its functioning, you then do what's called accidental discharge testing. Is that right?
That was after the microscopic comparisons were done, so that was the last test that I did.
Okay, so you do the functionality, then you do the microscopic examination we saw, and then you do the accidental discharge.
Correct.
Okay. Now, the accidental discharge, you mentioned that you consult the FBI SOP.
That's correct.
An SOP is a standard operating procedure?
Yes, sir.
Now, under that standard operating procedure, were you to do a type of test called a drop test?
So the drop test is, I would say that's a subcategory of accidental discharge where I physically drop the firearm to see if it will fire. And that is typically only done if that is as the situation has been reported by the contributor. So that was not relevant in this case.
Okay, when you say in a drop test, you can tell the jury more, that's when you, from a distance of about 4 feet, drop the weapon, and if it lands and it fires, that's what you're trying to determine, correct?
It depends on how the situation is being reported. So within that same SOP, it provides the examiner some discretion as in regards to how that is believed to occur. So for instance, say I'm cleaning my gun and I accidentally knock it off the table and I'm saying that caused it to fire. I would try to replicate that situation. If I had a gun leaning against a door and I'm saying that the door opened and the firearm fell, I would try to replicate that situation. So yes, the traditional drop test is just it being held as you would to shoot it and dropping it, but there is some discretion that's allowed if it is being reported in a certain way.
Okay, and you're familiar with SAMI standards, are you not?
Yes.
And SAMI is the Sporting Arms and Ammunition Manufacturing Institute, is that correct?
That is correct.
They were commissioned by the federal government about 100 years ago to come up with industry-type standards?
I don't know when they were instituted, but yes, they come up with standards for ammunition as far as dimensions and things like that.
1926. Were you aware of that?
Not off the top of my head.
Okay. So in their SAMI standards, there is a standardized drop test. You're aware of that?
I'm not.
Okay, but that's the industry standard for firearms across the country. This type of testing, right? Multiple states use this?
I wouldn't say that's the industry standard, and also their industry is different from the forensic industry.
Okay. And you also know there's no type of shock test you know what a shock test is?
In regards to what?
Well, it's kind of what you did with the mallet. Are you familiar with the National Institute of Justice? They call it a shock test.
I'm not familiar with that test.
Okay. So when you made your determination to hit that revolver with a mallet, is that part of the SOP that you hit it with a mallet?
That is written in the SOP, yes.
How many times have you done that as a forensic examiner? How many weapons you've done that on?
I would say probably less than 10, and this is the first one that I've had in actual casework.
Okay, so in actual casework, what do you mean by that?
As opposed to training.
Oh, in training. So the other 9 were done in training when you hit it with the mallet.
I don't know the exact number, but yes.
So this is literally the first time in your career as a forensic examiner that you've ever, in cases, hit a revolver with a hammer.
That is correct.
So is it fair to say you've never had this situation where you've hit a revolver and it's broken before?
Not in a case.
Okay. Did that happen in training?
I don't know about it specifically being a revolver, but yes, I have done it in training where the firearms do break.
And you earlier told us that you base your discretion on that accidental discharge test on input given to you about what might have happened.
Not the accidental discharge test. That would be the drop test.
Drop test. So you didn't have any information this was hit with some kind of hammer on the rest set, correct?
That's correct. I did not.
Okay, but you chose to do this, and then you hit the weapon with the hammer resting in the resting position, right?
Yes.
And then you did in the full cock position, correct?
It was not in that order, but you are correct.
Okay, and I'm not trying to mix it up, but when you hit it with the full cock position, that's when you broke the internal components.
Yes.
Now, do you know how hard you hit that?
I do not.
So on a drop test, would you agree with me? You're trying to eliminate variables. So in other words, gravity is the same, right?
Sure.
Gravity's not going to change. So if you drop that gun from 4 feet every time, and you know the weight of that gun, you're eliminating variables, correct?
I suppose so.
Okay, well, have you been taught that at all? In the FBI?
No. The purpose of these tests is not to figure out exactly what height or exactly what amount of force or exactly how many numbers of times you have to strike this firearm to get it to fire. It's just to try to generally replicate the situations and see if the firearm will fire without pulling the trigger.
Well, sir, so did you ever measure the trigger pull force on that revolver?
I did.
You did?
Yes.
What was the trigger pull force?
May I refer to my notes?
Yes, sir.
Between 2 and 2.5 pounds.
2.5 pounds, okay. Did you measure the weight of that firearm?
The weight of
the revolver?
No.
Okay. So, and you have no idea the foot-pounds of pressure that you were applying to that hammer when you hit it with the mallet, correct?
Right. There's no way to quantify that.
And there's no way to quantify when you do that 6 times if you're hitting it the same amount every time, right?
That's correct.
As a human being, I mean, you're not going to hit it the exact same every time.
I believe that's true, yes.
Okay. So, as we sit here, we don't know what amount of force was required to break that hammer and the internal parts, correct?
That's correct. We do not.
Okay. So if there was a question whether or not an external force of some type hit that hammer, we don't know from your testing what amount of force that was that would cause that.
You are correct.
Okay. If you were you given any other information regarding the accidental discharge testing that you can recall?
Initially that test was not requested. It was not part of the initial exam. That the decision to do that test came in later conversations with the case agent.
Okay. So initially, they did not even ask you to do that, but it was sometime later they did.
Correct.
And did you have any understanding as to why you were going to do that?
I believe it had something to do with one of the individuals involved stating that the trigger was not pulled.
Was that Alec Baldwin?
I believe so.
And based on your testing on the functionality, that comment about the trigger not being pulled could not have happened.
I wouldn't say, I can't say it's impossible because I can't account for every single variable. All I can testify to is the results of my testing. Okay, so when I received the firearm and I did that initial function examination, it did not appear that any of the safeties were malfunctioning or anything like that. So it was functioning normally when I received it.
And to be fair, sir, you did indicate earlier you do this in a lab. So you can't account for all the variables that might occur on a movie set, for example.
Sure.
Okay. So your testimony, and you're telling the jury that you can account for the variables you're aware of, but you cannot account for variables you might not be aware of.
Sure.
Okay. And some of those variables, and we'll come to the rounds in a little bit, but some of those variables include if you do not receive evidence or request to test it, you're not going to test that, obviously.
That's true.
Okay. With regard to the hammer testing, you mentioned earlier that this could be destroyed permanently as part of your testing. So you got permission to do this test, correct?
Yes.
And that would have been for the sheriffs?
Well, my point of contact was a special agent out of Albuquerque. So I would funnel information to him. He would discuss that with the detectives, and then they would distribute the answer back to me.
And that was Jose Cortez?
That's correct.
Okay. And Mr. Cortez is the one that sent you the request by written submission for what he wanted you to do, correct?
As far as the communication, is that what you're referring to?
Yes, sir. I'm referring to your report. There is a submission October 28, 2021 from Jose Cortez requesting various tasks to be done.
Yes.
Okay, and then there's another one, 12/14/2021. Same thing. So he's your liaison that goes back and forth between the sheriffs and yourself, and he makes those requests.
That's correct.
Okay. Now, so you got permission to possibly destroy this revolver permanently. They gave that to you.
I received permission to conduct the test.
And you made it aware to them that this could destroy the weapon.
Yes.
Okay. When you did destroy that, you broke several internal parts?
Yes.
Okay. And then we saw that on the exhibit. You took those apart to show what had happened. Correct?
Correct.
Okay. Now, you also said that you did not see any modifications as to that firearm, correct?
At what point?
You testified that in your functionality examination, you also determined whether it had been modified or not.
Right. So that's generally in regards to things like, has the barrel been cut? Has the stock been cut? Has this been modified to fire fully automatic? So when I talk about modifications, that's what I'm referring to, and I did not see any of those things.
Okay. And as far as internal modifications, did you look at that?
No, because I can't disassemble the firearm because I have to test it in the condition it's received.
Okay, but from your viewing it and your observation, you didn't notice anything that would tell you it was modified.
Right, nothing jumped out immediately.
Okay. Now, you also mentioned that the full cock notch, which was the one we saw in that picture, kind of a little circle. You remember that?
Yes.
Okay, sir, you said that it looked a little flatter potentially?
Compared to the quarter and half cock, yes, it didn't have as much of a claw shape to it.
But you could not, you did not conclude that that had been modified. You're not certain it had been modified.
Right, I'm not certain. It's a very small surface that we're talking about. So it's possible, it may have been modified, it may have been damaged during the exam, or it could also be one of the firearms that just doesn't have a very pronounced sear notch there.
Okay. So you just don't know for sure.
Correct, I don't know.
Okay. Now, I want to turn to the rounds. One of the things I heard you say several times is there's 4 components to determine a live round. Is that right, sir?
Yes, a live cartridge has 4 main components.
And you said the case, the projectile or bullet, the primer, and then the powder.
Correct.
So you also testified earlier that when you were given presumed live rounds, but you did not disassemble them, you could not confirm they were live because you didn't get inside to see the powder.
Right, so there were certain cartridges that, again, I discussed this plan with the case agent, the contributor, to try to figure out which ones we needed to take apart. So there was a subset that we concluded needed to be disassembled. So for example, the ones that were presumed to be live, we needed to see what was on the inside of those cartridges. However, they sent quite a few live, presumed live cartridges. So it didn't make sense to take apart every single piece of ammunition that they sent in. So we came up with a sampling plan to where we just determined we were going to take apart some of them as a representative sample.
Sure, and I guess my question too was, you can't tell something is a live round until you make that final step to determine if there's powder inside.
Yes, that is true.
Okay, so you could not, for example, in your FBI training, you could not look at a picture and determine that's definitively a live round.
I wouldn't do that based on a photograph, no.
Okay. And that's part of your FBI training, that you would have to go through the 4 components, take it apart, make sure there's powder, and that's what gives you the confirmation, correct?
I would say yes. In order to know for sure, you would have to be able to see the powder, yeah.
Okay. That's how you've been trained.
I would say it's training related to ammunition and just understanding the components of the ammunition.
Okay. Now, as part of this also, you identified rounds that were live, and those were items, and we saw it on the last slide, items 1B 4 through 7. Is that correct?
Those aren't the 1B numbers, I don't believe. It's the lab numbers, and it was items 4 through 7 and 13-1.
You're right. I'm sorry. Yeah, it was 4 through 7 and 13-1.
Correct.
Were the lives. Okay. Now, you later in December received a request from Mr. Cortez, Agent Cortez, to conduct DNA testing. Is that right? Your lab did?
I'm not completely certain of that.
Objection Foundation.
And I can ask a question on that, Your Honor.
Okay.
Does that request for DNA testing go to you, or does it go to another person in your lab?
I'm going to object to Foundation again. If he doesn't know what request he's talking about, he can't answer.
Can you be more specific?
Yes. And I can show you, sir, the report.
I'm objecting to Foundation. Why are we showing him a report that he hasn't seen?
You haven't seen your own report? Have you seen your own report?
My report would not include anything related to DNA, so I'm not sure which report you're referring to.
Okay, I'm just referring to the submission to the FBI lab by Jose A. Cortez, dated 12/14/2021. And did you see that?
I'd have to look at it.
Okay. If I may approach, Your Honor?
Hold on for a second. Are you having a problem with it? Okay.
All right, sir, I'm going to show you this request from 12/14/2021. If you could just look at it, don't tell us what it is, but just read it to yourself. And you don't have to read the whole thing.
Okay.
Is your memory now refreshed on that?
So that is not my report. That is an electronic communication from the field office, the case agent being Jose Cortez.
Okay, and you did not receive that personally?
Eventually I received that.
Okay, so you have seen it?
Yes.
Okay, so you know that certain standards were submitted in this case. Are you aware of that regarding fingerprints and DNA?
I'm sure I've seen that, but that's not related to my discipline, so that doesn't affect my examination. So I don't know that that's not noteworthy to me.
Okay, so you reviewed it, but you did not participate in that?
Correct.
And right as we're sitting right now, you don't know what was submitted in terms of the people and their standards. Is that right?
I do not.
Okay. With regard to the live rounds we were seeing on those exhibits earlier, did you measure the projectile tops on each of those rounds?
No, I did not.
And so you're not able to tell us whether there are differences at all or not in the size of those projectile tops?
When you say the top, you're talking about the flat portion?
The flat portion.
And you're referencing the diameter of that flat portion?
Correct.
No, I can't tell you if those are consistent, just the shape is consistent.
Okay. When you took the powder out of the rounds, did you weigh that powder?
I don't believe I did.
Okay, so you're not certain whether the rounds were full of powder or partially full of powder or not?
I'm not.
Okay. Let me ask you, going back to the gun, I missed one question. Before you conducted that test fire, did you look in the barrel with the bore scope?
No.
Okay. With regard to the rounds that came from Seth Kinney, you were told you have them in your report, and the Monroe Street address, you have no idea what time those were seized or what date those were seized?
I don't off the top of my head. That may be in the paperwork that was submitted, but I don't know that.
Okay. And you have no idea where Seth Kinney brought the rounds that he submitted?
I do not.
And he didn't submit them to you, correct?
No, we received evidence from the case agents.
Okay. And you didn't personally conduct any fingerprint or DNA testing because that's out of your specialty?
That's correct. I did not.
Earlier, you were talking about the different types of ammo from 126 Monroe Street. Do you recall that you were showing live, dummy, and blank, all three types?
Can you ask that question again?
Sure. As part of your examination of the rounds from 126 Monroe Street, you're aware that there were live rounds, blank rounds, and dummy rounds.
Objection. That misstates the facts that are already in evidence.
Let him answer the question.
Do you have specific item numbers that I can reference?
Well,
I can ask for clarification if that's helpful.
Sure, absolutely. We saw some exhibits from 126 Monroe Street, and if you want to look at your report to check out those items and determine if there were both live rounds, dummy rounds, and then if there were blanks.
Okay, may I answer your question?
Yes, sir.
So the ammunition that I have as being reported from that address includes items 28, 31, 32, 33, 34, 35, 36, and 37. And these were the cartridges that were submitted as being known live ammunition. Some of them I disassembled, but not all of them because there were too many. So all of these were either physically consistent with live ammunition based on their exterior appearance, or the ones that I actually did disassemble, I could determine it had the 4 main components.
Okay. All right, and thank you for looking for that. Now, with regard to the set, the live rounds you found on set, did you do any further testing on those with regard to the powder or anything like that, or is that out of your discipline?
That goes beyond my discipline. There was another unit that did some testing on the powder, but I can't testify to that.
Okay. Your Honor, may I have just a moment?
Yeah.
Your Honor, thank you. We have no further questions.
All right, thank you. Redirect.
Briefly, thank you. Mr. Ziegler, why not disassemble every round that was provided to you that was what I'm going to call presumed live?
All right, there were hundreds of rounds submitted in total. So for instance, you may have one item number, but that was an entire box of 50 cartridges. So in totality, just from practical purposes as well as, you know, what is the result, what impact will this have on the result, it didn't make sense to disassemble every single cartridge that was submitted.
Did you x-ray any of the ammunition that was provided to you that was presumed live?
Yes, I x-rayed every cartridge that was submitted.
You x-rayed every single cartridge?
I did.
So you didn't disassemble every single cartridge, but you x-rayed every single cartridge?
That's true.
What did the x-ray images tell you about those presumed live cartridges?
May I refer to...
Certainly.
I just wanted to verify I did x-ray every cartridge. And what that told me is there were indicators in the dummy cartridges that I could see in the x-ray. So whether they would be the holes in the size of the cartridge case, I could see that on an x-ray, as well as some of them had metal BBs, so the metal BBs showed up in the x-ray. So the live cartridges, the gunpowder does not show up, that's not visible. But I didn't see any of those other indicators to suggest that they may be something else that, you know, other than what they were reported as being.
And just to be clear, the dummy cartridges that you examined and disassembled, there were no dummy cartridges that came from 126 Monroe Street.
That's correct. Every cartridge that I have as being listed from that address was either consistent with being live or I actually disassembled it and it had the components of being live.
And when you say consistent with being live, not only are you talking about the physical characteristics, but also the x-rays.
That's true. There was no indication from the x-ray that they were anything else.
You testified on cross-examination that of those live rounds that were provided to you, you took a representative sample, and those were the ones that you disassembled.
Correct.
Can you tell us how you decided which rounds to include in your representative sample for disassembly?
Right. So as I mentioned before, working with the contributor, there were certain ones that they needed to have disassembled, but then when it came to these exemplars, we agreed to do a random sampling. And the way that I chose that, it was random as far as the item numbers go, but I also looked for cartridges that had similar head stamps. So I was trying to see if similar exemplars might have similar features on the inside.
In any of the presumed live rounds that you disassembled after putting them into your representative sample, did any of them turn out to be dummies?
Yes, there was actually one that from the exterior appearance and the x-ray, I didn't see any indication that it was a dummy round. And then after disassembling that, I found there was no powder, and you can see down into the primer pocket, it was hollow, so it was an inactive primer. So there was one cartridge that was submitted that on the outside appeared live, but upon further inspection did not have the 4 components required to fire a cartridge.
Can you tell us what item number that was?
It was item 22.
And can you tell us what your understanding was in terms of the description, where item 22 came from? And specifically, I'd like to know, did it come from 126 Monroe or Mr. Kenny?
Item 22 is a cartridge from the item 20 box, which is a box with tape from the prop truck.
Thank you, sir. Do you have to measure those projectiles or bullets to be able to see that they are different than the projectiles in the live rounds from the movie set?
No, they have distinct shapes in morphology, and some of them have distinct coatings, such as one of the projectile was a nickel-coated hollow point bullet.
You can just see that with your naked eye.
You can, and the photographs with glare and the print quality may not show it as well, but if you had the bullets, the cartridge in your hand, you would be able to see distinct shapes.
All of the items that you had, that you tested, that you examined, when your testing is complete, what do you do with them?
They get packaged in their appropriate outer packaging, and then they get returned to the field through, we have a unit at the laboratory that helps us out with this called the Evidence Management Unit. So they basically inventory everything, make sure everything that's supposed to be there is still there, and they're the ones that ultimately return it to the field.
And when you say they return it to the field, does it go right back to the Santa Fe County Sheriff's Office?
Typically, if it's associated with an FBI case, it's going to go to the FBI field office.
Do you know what happened in this case?
I do not.
Okay, thank you. Nothing further.
All right, you're excused. Thank you.
Thank you.
Let's take Paul Shannon first.
To remind any witnesses in this case that haven't been called, except expert witnesses, to stay off the live stream.
Face the judge and raise your right hand.
Do you swear or affirm under penalty of law that the testimony you'll give in this case will be the truth, the whole truth, and nothing but the truth?
Yes.
All right, have a seat talking to the microphone.
Good morning.
Good morning.
Would you please state your name for the record?
My name is Shannon Prince. My last name is spelled Prince.
And where are you currently employed?
I'm currently employed at the FBI laboratory in Quantico, Virginia.
And what's your title at the FBI?
I am a physical scientist, forensic examiner.
How long have you been employed in the latent print discipline?
Over 19 years.
And are you a member of any professional organizations related to your employment?
Yes, I am. I'm a member of the International Association for Identification.
And do you instruct any courses in the latent print discipline?
Yes, I do. I instruct courses on latent print processing, which is using chemicals to develop latent prints, as well as post-mortem processing, which is using fingerprints to identify the unknown deceased.
And do you take proficiency tests as part of your ongoing work at the FBI?
Yes.
How often and how many?
I take one proficiency test each year in comparing prints, and I've taken one test every 5 years in processing latent prints.
Have you ever failed a proficiency test?
No, I have not.
All right. And are you a certified latent print examiner?
Yes, I am. I'm a board-certified latent print examiner with the International Association for Identification.
Great. Your Honor, at this time I move the court to recognize Ms. Prince as an expert witness in the area of latent fingerprint examination.
Any objection?
No objection.
All right, you're recognized as an expert in latent fingerprint examination.
Thank you. All right, why don't you give us an idea about what your duties are as a latent print examiner?
I receive a variety of evidence from either FBI field offices or state, local, and tribal officers. I receive this evidence in the laboratory, and then I examine that evidence with a variety of chemicals, powders, or light sources. When I develop latent prints, I then compare those latent prints to known prints of individuals and come to conclusions. I may search those latent prints in a fingerprint database, such as a computer, to make identifications. And then I provide a report based on my results. I can also testify in the court of law on those results.
You mentioned you work with a known fingerprint. Can you explain to us what a known fingerprint is?
On the palm side of your hand, you have these raised portions of skin called friction ridges. They form patterns on your hand. You also have them on the soles of your feet. In order to record a known print, the finger is usually rolled in black printer's ink and then rolled on a contrasting white background, such as a fingerprint card. And that creates a known print. These days, it's often recorded by placing your finger on a flatbed scanner, and it creates a digital copy of your fingerprint.
And you also mentioned latent fingerprints. What is a latent fingerprint?
A latent print is the unintentional or chance reproduction of your friction-rich skin when you touch an object. When you touch an object, you may leave a latent print. It's often left in the oils and sweat on your hand, but it can be left in other substances, such as blood, dirt, grease, ketchup. It's often not readily visible and requires a forensic light source, such as a laser, a chemical, or a powder to be made visible.
And how are fingerprints compared and identifications affected?
It's a three-step process, which is called analysis, comparison, evaluation, or ACE, ACE, where I analyze latent prints, looking if they're suitable. Then I can compare those latent prints and known prints side by side, and then making an evaluation decision, where I can make one of three decisions. An identification decision, the latent print and known print were made by the same person. An exclusion decision, where the latent print and known print were not made by the same person. Or an inconclusive decision, where I don't have enough information to make a conclusive decision. Often this is times when a fingerprint card, like a known card, is smeared or smudged, or it has too much ink. I can't make a conclusive comparison because that print is too poor to make a conclusive decision.
Great. And when you receive evidence for latent print exams, what factors do you consider prior to starting your examination?
I look at what type of evidence it is. It could be a porous item, which means it's like paper or money or cardboard. I also look if it's semi-porous, which is kind of a shiny cardboard, or if it's non-porous, which is smooth or shiny, like aluminum, plastic, glass. So I look at what type of evidence it is to determine what chemicals or light sources I'm going to need. And then I look at the condition of the evidence. Is the evidence broken? Is it shattered? Is it dirty? Is it covered with something? Or was it previously processed in the field by a crime scene investigator? I look at all that in order to determine what exams I will do and how I will proceed with those exams.
Great. I'm going to show you what was previously marked as State's Exhibit 63. And let's see. Do you recognize that photograph?
Yes, I do.
Have you actually seen the original version of what that photograph demonstrates before?
Yes, I have.
All right. And where did you see that?
I saw that back at the FBI laboratory in Quantico, Virginia.
All right. And did you examine Exhibit 63 for latent prints?
Yes, I did.
All right. What specific examinations did you conduct on this item?
So this item of evidence is an ammunition box, and it's semi-porous, meaning it's shiny paper, but it also has non-porous qualities. So the first examination I do is simple visual examination, looking to see if there's any visible prints. You do this every day when you see fingerprints on your cell phone or on a garage door or a mirror. That's a visual examination. So I first do that exam. And then I take this box into a dark room where I have a green light or a laser, a blue light or an ultraviolet light, and I shine that light on the object while I'm wearing orange or yellow goggles to see if any prints may fluoresce. At this point, I've used no chemicals on this item. The next process I use is called superglue fuming, where I place this item in a chamber, I hang it in a chamber, and then in the chamber I heat superglue at a high temperature. The superglue starts to fume. It starts to appear like white fumes. Those fumes adhere to any kind of moisture that might be on that object, and it creates a white print. And I can either see that print visually, or I need a reflective ultraviolet light to be able to see those prints. Then I also do a magnetic powder right after that process. The magnetic powder is black, since it's the white box, so it's contrasting. And I can see if there's any visible prints that way. The black magnetic powder adheres to the white superglue prints. And then I take this box and use a chemical called indane-dione, I-N-D-A-N-E-D-I-O-N-E. This is a chemical that is sprayed on the item, and then it is placed in a humidity chamber where a chemical reaction is sped up. This chemical develops any kind of amino acid that may be in your sweat, and it creates a pink or orange print. And I can see that print either visually or in a dark room with a light source. And finally, I take a fluorescent dye stain and I spray this orange chemical on this box, and it adheres to those superglue prints as well, and I can see those prints in a dark room with an ultraviolet light or a laser.
And just to be clear, you did all of that, you did all of those tests with regard to the box that's in this photograph, correct?
Yes.
All right, and what was the result of your testing?
On this box, I developed 10 latent fingerprints.
All right. Did you compare the latent prints that you detected on Exhibit 63 to the known prints of any individuals?
Yes, I did.
Which individuals did you compare those known prints to?
I compared these prints to Hannah Gutierrez, Sarah Zachary, David Halls, and Alec Baldwin.
And did you find a match?
Yes.
Who did you find a match for?
2 of these latent prints were identified to Hannah Gutierrez.
All right. And were you able to find matches to any of the other known samples?
No.
All right. And were you able to exclude any of the other individuals based on your test?
The remaining prints were excluded as being prints from Sarah Zachary, David Halls, and Alec Baldwin.
Thank you. Did you also examine a second ammunition box as part of this case?
Yes.
Does this appear to be a photograph of that box?
It is.
All right.
Can you give us the exhibit number?
Oh, I apologize. This is State's Exhibit 48. Where did you see this box prior to today?
At the FBI laboratory in Quantico, Virginia.
All right. And did you examine this box for latent prints?
Yes, I did.
And did you conduct the same type of analysis that you did on the previous box?
Yes. The examinations I conducted on this box were the exact chemicals, light sources, and powders that I used on the previous box.
Great. And what was the result of your examination of this box?
There were 3 latent fingerprints detected on this box.
All right, and were you able to compare those latent prints to the known samples of any individuals?
Yes.
And who were those folks?
I compared the 3 latent fingerprints to Hannah Gutierrez, Sarah Zachary, David Halls, and Alec Baldwin.
And did you find any positive matches for any of those individuals?
There were no identifications.
Were you able to find any exclusions?
Yes, Sarah Zachary and Alec Baldwin were excluded from the 3 latent prints detected on this item, and Hannah Gutierrez and David Hall were inconclusively compared to these prints.
All right. So just to be clear, Sarah Zachary, you didn't find her fingerprints on this box whatsoever?
The 3 latent prints were excluded from being Sarah Zachary.
Great. Is it possible to touch an item and not leave a latent print?
Yes.
And what kind of circumstances might that occur?
There are several circumstances where you can touch an item and not leave a latent print. First of all, you could be wearing gloves or a mitten, and when you touch an object, you may not leave a latent print because your skin is not having contact with that object. You may have too much sweat or too little sweat on your hand, and that may not leave a latent print. The surface itself may be dirty or textured, and it's difficult to leave a latent print on a dirty or textured surface. The print may be on a surface where if it's overhandled, such as if I put my hand here, and the next person comes and put their hand here, someone at the end of the day puts another hand here, it's overhandled, and that could wipe away any prints that may be on an item. There's also environmental conditions, wind, rain, snow, heat and humidity. Those can all play a factor of whether a latent print is detected on an item.
And did you attempt to do any examination of cartridge casings in this case?
Yes.
And what was the result of that examination?
I examined 4 cartridge cases, and there were no suitable latent prints detected on those cartridge cases.
And is it unusual for you to be unable to identify a latent print on a cartridge casing?
It is not unusual.
And why not?
Cartridge cases, when they go through a firearm, there's a lot of heat and friction, and that can destroy a latent print. Also, it's a very small surface that's on a cartridge case, so leaving a suitable print can be difficult. And it's also a smooth surface, so any kind of movement that comes into contact with a cartridge case may destroy a print on a cartridge case.
Great. Have you worked on any other cases where there were a large number of cartridge casing rounds that you attempted to examine for latent prints?
Yes, I have.
Can you give us an example of a case where you worked and then and explain to us, based on the number of casings that you found, how many actually were found to contain latent prints?
A case that I have been a part of was the Las Vegas shooting several years ago, where there was a significant amount of firearms, ammunition, and magazines in that case. Specifically to the ammunition, which consisted of shot shells as well as cartridges, we processed and examined over 6,900 pieces of ammunition, where we only detected 26 prints on those 6,909 ammunition. That's 0.38%, so it's a very low chance of developing prints on ammunition. We also processed firearms in that case. We processed about 40 firearms in that case, and we detected prints on 12% of those firearms. And then we processed over 180 magazines in that case, and we only detected prints on 9.7% of firearms. So it's a very low chance of getting prints on firearms or ammunition based on the size of the item, the texture of the item, as well as overhandling of those items. Those are all reasons why there's a low recovery rate on firearms and ammunition.
Thank you. And the 4 cartridge casings that you attempted to do fingerprint examination in this case, on your notes, does it indicate what the source of those cartridge casings was?
I'd have to refer to my notes for the specific source of those cartridge cases.
Do you mind?
May I?
Yes.
I don't have a specific source. I just have the Santa Fe Sheriff's Office item number.
Do you mind providing that?
It's item 144.
Okay, thank you. I have nothing further.
Cross-exam.
Ma'am, good morning.
Good morning.
With regard to your work, when you compare a Latin print against a standard, you are given those standards from the agency. For example, here the sheriffs, correct?
Yes.
So here you have 4 people as standards. Is that correct?
Yes.
And that was Mr. Halls, Sarah Zachary, Alec Baldwin, and Hannah Gutierrez Reed. Is that right?
That's correct.
Okay, so one of those people you did not receive standards from is a guy named Seth Kenny, correct?
Correct.
And so of all the other people on the set, the only 4 you received standards from were those 4.
That is correct.
Okay. And those standards included Latin prints, fingerprint cards, and DNA?
The standards I received were fingerprints and palm prints from Gutierrez, Zachary, and Halls, and I only had a fingerprint card for Alec Baldwin.
Okay, you didn't have a palm print for him?
I did not.
Now, I know that you had stated that Halls and Hannah Gutierrez Reed, Mr. Halls and her prints were not completely rolled, or they were over-rolled?
Correct. Their known standards were not complete. There was some over-inking in one area, and when a fingerprint card is fully rolled, it's usually from nail to nail, where you can get the whole finger. This case, on some of these standards, the finger wasn't fully rolled completely. Therefore, I did not have enough information to do a conclusive comparison.
So when you don't have that completely rolled from the agency submitting to you, it's difficult for you to do a conclusive comparison.
It does make it difficult.
Okay. And that was the case here with Ms. Gutierrez Reed and with Mr. Halls?
Yes, it was.
With regard to the prints that you were able to conclude, and you indicated Ms. Gutierrez Reed's prints were found on one of the boxes?
That is correct.
Now, you were able to conclusively do that because?
I was able to conclusively do that because some fingers had that comparable area. So if there was an area that I can compare completely, I can make that conclusive decision. And in those 2 identifications, I was able to conclusively compare and make an identification.
And with regard to the other box that we saw, you found 3 Latin prints.
That's correct.
And you indicated that Ms. Zachary and Mr. Baldwin were excluded, correct?
Correct.
And that Mr. Halls and Ms. Gutierrez Reed were inconclusively compared, is that correct?
That is correct.
And that was because, again, you told the jury that you didn't have a complete, well-rolled set of fingerprints.
That is correct.
All right. And that would have been something the agency, the sheriffs would have provided?
Those standards came directly from the sheriff's office.
Did anybody ever communicate with you, and was there communication regarding we need new fingerprint standards?
There was no communication. In my report, I indicated that if further comparisons needed to be conducted, that standards would have to be submitted.
In your report, and if you need to refer to it, refresh your memory, you did not conduct fingerprint analysis on items 4 through 7 and item 13.1, correct?
I'd have to refer to those specific numbers.
Absolutely.
You said 4 through 7?
4 through 7 and 13.1. 13-1.
I did not conduct examinations on those items.
Okay. So the ones that you conducted it on, we've seen today?
Yes.
Okay. Now, with regard to the case you worked on, the Las Vegas shooting, you talked about the low percentage and the ability to recover prints from fired cartridges, correct?
From all types of ammunition.
Okay. Now, with regard to unfired ammunition, they don't go through that heat of the barrel, correct?
That is correct.
And so does that make it more likely prints can be found on those cartridges?
The same percentage refers to that as well. less than 1%. It's due to overhandling of cartridges or shot shells, the surface, the smooth surface, and a variety of other reasons that it could be a low chance of recovering prints on unspent cartridges.
On unspent cartridge, okay, but it is possible, even very low possibility, it is possible to recover them.
It is.
Okay. And you have listed there's certain elements that might come into that, like overhandling, that kind of thing. For example, the box you said earlier, that was handled by another unit?
The box, what specific box are you
Oh,
talking
I'm sorry,
about?
not the box. I was talking about, you mentioned in your report that there was some overhandling and one of your employees came up as contributing 8 fingerprints to one of the items.
Correct. One of the boxes was sent to the firearms unit first, which is usually on the latter end of examinations when it flows to the laboratory. But this box came in, it was specifically for that unit. And then after the firearms examinations were conducted, the request was to do latent prints. So it was kind of backwards in order. Therefore, this item of evidence was handled by the firearms unit, and a firearms employee was identified on that box.
And that was 8 of the prints out of a total of 10 or 11 were the employee, right?
8 out of 10 were identified to an FBI laboratory employee.
And ideally, that should have gone to you first?
In a regular case, the evidence is usually where it goes to a unit that can have less destructive examinations on it to more destructive. That's how it kind of moves to the laboratory. And this box initially went to the firearms unit first.
Okay. Thank you, Your Honor. No further questions.
I just have one quick question for you. Mr. Bowles mentioned items 4 through 7 and 13-1. Can you tell the jury why you weren't able to perform a print comparison on those cartridges?
I do not are they cartridge cases? I don't have them in my report, so I never received those items.
Okay, fair enough. Thank you.
All right, you're excused. Thank you.
Thank you, Your Honor.
We're going to take our lunch break now. All right, so be back downstairs at 12:30. Please don't talk among yourselves or anyone else about the evidence received here in court. Thank you. Take your tablets with you.
All rise for the jury.
We're in recess.